Welcome to, good afternoon, ladies and gentlemen, and welcome to the Rules and Elections Committee. We will soon be joined by members of the Personnel Committee, and this will become a joint committee, but in the meantime, this is just a Rules and Elections Committee special meeting, and later special joint meeting with Personnel Committee. It's Wednesday, October 20th, 2010, and we're in the John Ferraro Council Chambers, room 340. Myself, Eric Garcetti, and Councilmember Janice Hahn are here, so we have a quorum. I think what we will do is, because items, well, let me just say that at the outset, items 1 and 2 were part of the same council file that had to do with pension reform broadly. Rules and elections, it's not my opinion, has jurisdiction over this if it's not something going to the ballot. And for civilian pension reform, I believe the discussions are to sit down and talk with our union partners and to carry that discussion forward. So I'm going to refer that just to Personnel Committee to take up, so that we won't take up the civilian pension reform piece here today. We do have some civilian employment provisions that do need to go to the ballot that we will take up today, and the sworn pension reform. So we'll take numbers 3 and 4 when we have members of the Personnel Committee, which I understand are meeting right now upstairs. So with that, why don't we take up item number 8 first. Let's go in reverse order, and then we'll take the elections package, unless Mr. Huizar is here already. I know Mr. Huizar wanted to be here for some of them. So let's go ahead and take up item number 8. This is the city contract entity campaign contribution item, and let me see if we have cards on 8. We don't, but I'd like to ask we asked the Ethics Commission, and I paid a visit to the Ethics Commission last week and had a good discussion with the commissioners and asked for their feedback and input. But why don't we read aloud what it is, Mr. CLA, and then we'll turn to the report on number 8. Or Madam Clerk, excuse me.
Okay. Item number 8 are Chief Legislative Analyst, City Attorney, City Ethics Commission reports relative to a proposal to revise the city charter to add a new provision which would prohibit campaign contributions from entities bidding on city contracts pursuant to motion Garcetti, Krikorian, Koretz, Reyes, Rosendahl.
Just to frame this again, many of you were here for the earlier discussion of this, but this is something in which we just kind of had an ongoing loophole. This was something 2 years ago that we, or 3 years ago, I think we looked at. I know Mayor Hahn had wanted to move something forward on this and left office before that could be done. We also had advice earlier on from the city attorney's office about some of the restrictions, but essentially this would put the onus on companies that were seeking contracts or entities that were seeking contracts before the city to have some sort of ban on them once those contracts were announced and for some period of time after that, and to be able to do that so that any perception of influence, a lot of bodies have this, we don't, as good as our ethics laws are. And the idea was not to make things even more complicated than they are right now, but to make them as straightforward as possible. So we do have one card on this, which we'll get to, but let me first ask the Ethics Commission to come forward with the city attorney and tell us what thoughts you had, and then we'll turn to the CLA, who I know also has some recommendations on this as well. So why don't we have all three at the table? Actually, why don't you frame it for us, Mr. CLA, first, and then we'll turn to the Ethics Commission City Attorney.
Certainly. Mr. Chair, this item is on, as you said, a possible prohibition or restrictions on campaign contributions by those who are bidding on city contracts or those who hold them. Before you are 2 reports, one from the CLA, one from the City Ethics Commission, and another report which contains more information and background on this item from the City Attorney. Both the CLA report and the City Ethics report recommend general support of your motion. There are some slight differences in what they actually recommend, but in general, both recommend that any prohibition or restriction be structured so that the restrictions are applied on bidders who are selected from contractors from the date their bid is submitted to a certain time period after the contract is signed. The CLA report recommends 6 months after the contract is signed. The City Ethics Commission recommends 1 year. At the previous committee meeting, this committee instructed us to look at 6 months, and that's why we are on that. Both reports recommend imposing restrictions on bidders who are not selected until the date that the selected bidder signs their contract. So everyone who submits a bid would be subject to this, and then once the city selects a bidder, that bidder signs a contract, everyone who is not selected will be free to go forward and make unrestricted campaign contributions. Both reports recommend applying restrictions to bidders on contracts that require substantial review and approval by an elected city official. On the advice of the city attorney, the CLA report recommends that an additional dollar figure be placed on that. We're recommending that the prohibition be placed on contracts of over $100,000. Although the contracts to which the prohibition should apply is certainly a policy decision that is up to this body, and that is only a guideline. You can certainly feel free to amend that to whatever you choose. The City Ethics Commission recommends that restrictions also apply to all subcontractors of a selected bidder. Our report only recommends that it apply to the principals of the bidder. There is some concern that the city doesn't really have a way to keep track of who all the subcontractors of any contract are at one time, and that at some point you may get very minute who a subcontractor is. If there's one who they contract out to say, supply office supplies, would they then have to be subject to the same prohibitions? Again, this is a policy decision that is before your body. Both reports recommend that restrictions apply to election campaign committees that are controlled by city officials and candidates. And they would require invitations for bids that regard contracts to include notice of the prohibition, and require those who are bidding on contracts to agree that they understand and will comply with the prohibition. On actually enforcing this prohibition, there are two recommendations before you, one from the CLA report, one from the City Ethics report. Both recommend that those who are violated, or those that are found to violate the prohibition, should be themselves prohibited from entering into a contract with the city for a certain length of time after they're found to violate the provision. The CLA report recommends that that prohibition be extended for 1 year after the date of violation. The City Ethics report is for 4 years. Obviously, this is definitely a policy decision that is before your body for you to decide. With that, I'll turn it over to the City Ethics Commission to add any more that they have in their report, and the city attorney is also here to provide advice as needed.
Good afternoon. Heather Holt for the City Ethics Commission. The Ethics Commission met and considered the proposed ballot measure and unanimously supports the concept of a ban on bidder contributions. As the CLA noted, the Commission spent a considerable amount of time going through some of the details that would be necessary to make such a ban effective, and did make some recommendations regarding those details. One of the items that was mentioned by the CLA is with respect to subcontractors, and the Commission did recommend that the ban apply to subcontractors. It did feel like the first level of subcontractors was sufficient, so that there would continue to be a nexus between the prohibited activity and the contracting that's at issue. And to facilitate that, because identifying subcontractors can be difficult, the Commission's recommendation was to require the bidders to provide notice of who their subcontractors are at the time they submit their bid documents, and to amend that as necessary if changes occur. The Commission I feel like the ban should extend for 12 months for successful bidders after the date of the contract being signed. If we have other ethics laws on the books that use 12 months as a standard time period in which to break ties of perceived wrongdoing, such as the revolving door provisions, and this would make it consistent with those provisions. And the Commission does feel very strongly that both contributions and fundraising from a policy perspective should be banned, because the amount of dollars that could potentially be in political play as a result of fundraising can far exceed the dollars that are put into play by a single personal contribution. The Commission does acknowledge that there may be some legal tension on that front, but from a policy perspective, that was their strong recommendation. And I'd be happy to answer any additional questions that you have.
Okay. Why don't we discuss the legal tension then? City Attorney, tell us what you think we can and can't do.
Good afternoon, council members, deputy.
We just move a little closer to your mouth so we can hear. Thank you.
Good afternoon, council members, Deputy City Attorney Renee Stadel. The City Attorney's Office presented a report to you with a legal analysis of various issues of instituting a ban. As a general matter, we believe the case law supports imposing a restriction on contributions for contract bidders. There's a lot of legal challenges that are ongoing. So
I'm having a hard time hearing you.
Okay.
Like, get it really close.
There you go.
Case law supports imposing a restriction on contract bidders in terms of their contribution activity. The key issue is whether a restriction is closely drawn to achieve its purposes. As we discussed at the last meeting, the governmental purpose to be served is avoiding corruption or the appearance of corruption, and so therefore the restriction must be closely tied to those contracts where those interests come into play. There are a lot of different moving pieces of such a restriction, and in terms of the case law, some of these areas are the following. One is it a contribution ban as opposed to a limit? There appears to be it appears to be slightly more defensible to have a lower contribution limit as opposed to a complete ban, because it still permits some level of political participation for those people who would like to give. Other jurisdictions have done it both ways. San Francisco has a ban. New York City has a limit.
What's the limit compared to what the normal contribution limit is?
So in New York City, for example, their contribution limit is 10% of what their general contribution limit is. So it ranges from, I think it's $350 or $400 for a contract bidder, or those people that are subject to their...
10% of the current, like they have 3,500 or 4,000.
Yeah,
limits.
right. The SEC has also adopted rules over time that apply to various investment professionals, and those rules provide limits as opposed to complete bans.
No, there's some bans, though, correct, from...
Right. It's my understanding that under SCC, bond companies can only contribute if they can vote for the person.
They can. There are varying contribution limits depending on. There's a lower contribution limit if you can't vote for the person, and a higher one if you can. Vote, but it's not a complete ban.
There's an outright ban, I think.
Bond companies have pretty consistently always said we're not.
That's what they tell you.
There's an amount that they consider a de minimis amount, and it's set at 250 under one rule, and it's different in another rule. Our existing provision about underwriters and non-competitive sales of revenue bonds that are proprietary departments, we have a $100 limit in there. The other issues that need to be considered are the duration of the ban. It appears supportable from case law to actually have the ban for the entire length of the contract, although the potential for influence seems to be more acute at the time of the selection of the process, and so may be more supportable and more narrowly crafted if it is for a shorter duration. Different jurisdictions have different time periods. I know San Francisco's is 6 months. Others, like Connecticut, and I think New York City's is the entire life of the contract.
And do any of them do anticipation of, like, if they're contracts that automatically renew or have the option of an automatic renewal, do they ever kick in before those renewals? Like, it's 3 years we often have contracts that are 3 years plus the option of, 2 years, 2 more times. Do they ever?
Some jurisdictions have, I'm not certain about the renewal question. Some jurisdictions also impose the limited time limit restriction as what the Ethics Commission proposed, which is to also apply it to contract amendments and change orders. In terms of the renewal, obviously for those jurisdictions that apply it for the entire life of the contract, it would continue to apply.
Yeah, okay.
The other area is, deciding which contracts this would apply to, and so one of the issues is, should it really apply to all contracts that are approved by City Council? Because City Council actually approves more contracts than those that are contracts under $100,000 for certain types of things. There's a tension there that maybe there is not as much of an issue with lower dollar value contracts. The other issue with it is from an administrative point of view. I know that San Francisco has recently considered their provision, and on Monday actually recommended scaling back their provision a little bit because it become kind of an administrative burden for them to deal with. One question is whether this restriction should apply to low bid, competitively bid contracts, and different jurisdictions apply it and some don't. And there's an argument that there really is less of a concern with of a potential risk for corruption on those types of contracts. And so that's a decision point that we would like the council to consider. In terms of the agents of the contractor and subcontractors, there's been litigation over how broadly that's defined. So we need to only cover those people that are really key to the organization. I have not seen litigation specifically over the subcontractor issue, but we have to recognize that not only is there a potential legal issue, but an administrative issue in terms of our subcontractors. And it may be that we only want to deal with certain contractors that represent a certain dollar value or percentage of a contractor, because if you apply it to all contractors, it's possible that you get, I think, as the councilman said at our last meeting, the supplier of staples on a contract, for example, and unintentionally so. The other major legal issue that we've reported to you on is whether this restriction should only be a contribution restriction or should it also be a fundraising restriction as well. And because of the nature of the case law right now, we don't believe that a broad prohibition on fundraising would pass legal muster, given the current cases. Whether a narrower restriction would survive legal challenge, we're not certain.
What sort of cases are out there right now? Are they where non-principals are fundraising?
So,
or are they principals, or what are they?
Yeah, the most recent case on fundraising was actually out of Connecticut. It was a Second Circuit case called Green Party versus Connecticut. It was a broad prohibition. There were several restrictions at issue in that case. It's a broad restriction on contractors and their principals, and I believe subcontractors. And the restriction. It was two restrictions. One was on contractors and the other was on lobbyists, and it was both on contribution activity and fundraising. The Second Circuit upheld the contractor contribution ban, but struck down the lobbyist contribution ban and struck down the fundraising bans for both sets of people. They found that the fundraising restriction was subject to a higher level of scrutiny because it actually involves speech, asking for contributions, and the Second Circuit determined that there really wasn't a compelling governmental interest, and even if they could find one, that the restriction that Connecticut had proposed was too broad, and it would have to be significantly narrowed. Earlier, not recently, another court had upheld a restriction, an SEC rule that had a fundraising component to it. So, but because of the nature of the campaign finance case law right now, we just aren't very certain that that the Ninth Circuit would uphold a broad rule, or perhaps even a narrow one.
And may I add a thought on
Sure.
that front? The Ethics Commission, the Ethics Commission's read of the Second Circuit case was that the fundraising prohibition was struck down because it was too broad, not that a fundraising prohibition in general is de facto impermissible. And the Commission did feel like the suggestions that it was making helped to narrow the proposed ban for the city of Los Angeles, in that it would last only for a finite period of time. It wouldn't be indefinite. It would apply to specific individuals. It would only apply to certain contracts, and the Commission's recommendation was that the contracts that would trigger the ban on both contributions and fundraising be those that are required by law to be approved by an elected official, thereby keeping the connection between possible appearances of corruption on the political money front and the decisions that are being made about contracts. In addition, the Commission put together some proposed language for instituting the ban, and specifically defined prohibited fundraising to be specific types of activity that are closely and traditionally tied to campaign fundraising activities. So in those ways, the Commission was trying to accommodate the concerns of the legal concerns about drawing a narrowly tailored ban.
So it was mostly on the timing? I mean,
I'm
'cause
sorry?
It was mostly on the timing. If I missed something, it seemed like the one that was broad, you recommended almost the same things: subcontractors, direct contributions, and fundraising. The only narrowing is the time?
The timing, the types of contracts that it would apply to, and the definition of fundraising. For example, in the Second Circuit case, one of the prohibited fundraising activities was serving as the treasurer of a campaign committee. And that's clearly broader than well, maybe not clearly, but that is definitely broader than what the Commission had in mind.
Okay.
Yeah, could you define fundraising activities?
I can tell you what the Ethics Commission proposes. The Ethics Commission's proposal is to define prohibited fundraising as asking another person to make a contribution, inviting a person to a fundraising event, supplying names to be used for invitations to a fundraising event, permitting your signature, name, or official title to appear on a solicitation, providing the use of your home or business to hold a fundraising event, paying 20% or more of the cost of a fundraising event, hiring another person to conduct a fundraising event, delivering another contribution in a manner that indicates that you are associated with it, and acting as an agent or intermediary in connection with the making of a contribution. This is reflective of a current provision in the campaign finance ordinance that goes into the definition of fundraising as well.
You guys aren't a part of it, but we're more than happy to hear your opinion.
Thank you.
I have a question about the definition that the Ethics Commission put forward in terms of the persons. It was a board chair, president, CEO, chief financial officer, chief operating officer, an owner of 20% or more, or an individual that's authorized on the bid for that contract from the company, right?
Yes.
Okay.
So basically, the recommendation is to prohibit contributions or fundraising activities. This is the Ethics Commission recommendation. How many months before the?
Just when it's announced would be the first date.
Yes, the Commission's recommendation with it is that the ban would begin on the date that a bid is submitted for that particular bidder and that bidder's agents and subs.
When the bid is submitted,
Yes,
not when the RFP hits
No.
the street. When
Exactly.
when
Once
their
they-
bid is submitted,
that's right, when you actually become a bidder.
right up to
For I'm sorry.
Up to you guys are recommending a year after the contract is signed?
For successful bidders. So in other words, those who become contractors, it would extend for 12 months after the date that they sign the contract. For unsuccessful bidders, it would end on the date that the contract is signed by someone else. So if you are not selected as the contractor, your interest in trying to influence how that contracting decision is made ends when the contract is entered into by another party.
Does that worry the city attorney at all? I'd raised the point before that, like, it's do the rental car company one again. So Hertz wins. They can't give for a year, but in the meantime, Avis and National and Alamo can start giving the moment they lose. In preparation, would that open us up to any sort of, then Hertz would say, how can I not keep up with my competitors who are now donating for this entire year? What if it's a year contract, for instance?
Or what if the successful bidder somewhere along the line becomes thrown out or disqualified, and the second one is automatically put in there who was allowed to give contributions?
Well, as long as I think we have to craft the proposal or the restriction or whatever we end up with in a charter and an ordinance to make sure that it doesn't unduly restrict people who are no longer part of the process. So to the extent that somebody is no longer in the pool of bidders, whenever that is, they should no longer be restricted.
But my point is, around here, many times you continue to be in the quote pool, because many times we've seen the first one get thrown out for various reasons. So you sort of always are in the pool.
Yeah, this proposal, this restriction requires a lot of thought and thinking into the fine points of it, so that it achieves what we want it to achieve, but without being overly burdensome and restrictive for both the city and for people who want to contribute to candidates.
But if I'm hearing you right, you would rather us err on the side of not restricting losing bidders, so you'd be more comfortable with an allowance of bids of contributions by losing bidders right away, even if we banned it on winning bidders, rather than to have them all banned for a period of time.
That's right,
Okay.
and that's what we've advised the Ethics Commission, and that's what we had advised and crafted several years ago when we were looking at it before.
Just looking at a scenario like what we've done with concessions, because certainly there were a lot of concerns raised during this recent process of concessions. What would be the scenario under what happened at the airport? One package was thrown out through the city attorney. There's now, there's future bids being awarded, probably to some of the same, but there certainly were losers that didn't get the first round, but there's second rounds and third rounds. How would you see this being implemented in a situation like that?
Well, I guess from my familiarity with the concessions situation, the way I would expect it to operate, and I'll let ethics jump in and CLA if they want to, those concession contracts obviously occurred through an RFP process. So once LAWA issued the RFP, and the entity that submitted the bid, that's when the restriction would start.
Right.
And the restriction would continue until unless they were knocked out through some as being non-responsible and that issue was fully resolved, they would still be part of the restriction until the council approved those contracts.
Okay. And even on the future RFPs, it doesn't happen until they submit another bid.
Right, because they don't many entities don't really know for sure if they are actually going to submit a bid or not.
So it happens the day they submit the bid. Okay.
Okay.
I don't know.
Go ahead.
Are you okay?
Keep going.
I think one of the other issues, I know it looks like we were certainly putting the onerous on the contractor. I will say off the bat, I feel like the 4-year ban is a bit harsh. I really don't think that punishment fits the crime. I would be more, amenable to the 1-year ban. I think 4 years is a bit harsh. But however, it still would be a violation on the person running for office, right? So if you accept a contribution, you would still be, you would get a fine or a infraction or whatever the Ethics Commission decides. So it's not just on them. It'd be nice if it was just on them, but...
Yes, the Ethics Commission's recommendation is that some responsibility lie with the recipient as well as the donor. However, they did make a distinction between those two types of responsible parties by saying that it really should be the recipient who knows or has a reason to know that the donor is prohibited from giving. And the reason for that is that the city's contracting process is very decentralized, and there is no standard process. There is no central database that a recipient could go to say, is this person prohibited or not? Which is in contrast to the lobbying contribution ban that's currently in the charter.
Right.
We do have a real-time database of who is a lobbyist at any given moment, so recipients can check that. But because of the complications with determining who would be prohibited when you're on the receiving end,
right.
The commission did feel like a know or should have or has reason to know standard is appropriate.
And because of the questions
And there was something in there I read that the department had to notify.
Yes, and to facilitate the knowing and the compliance, the commission's recommendation.
It's to the Ethics Commission, so you would be the central clearinghouse for all these?
Well, actually, the commission's proposal was that the departments notify the elected officials directly when new bidders are entered into the competitive process.
It's like Metro, but yeah, that relies on a lot of different departments.
Wow. Okay.
Yeah, it's a lot of information.
I think a better suggestion would be the Ethics Commission becomes the clearinghouse, so that there's one place for elected officials or non-elected officials who are running for office have a place to go. Because are they going to notify everybody who's running for office? We have a hard time getting information out of our departments on basic things. I can't imagine them notifying everybody running for office.
Yes, and the commission.
I think a better thing is that you become the clearinghouse. Departments let you know when and give you a list of the contractors and bidders, so that anyone running for office in Los Angeles can go to you and find out whether or not that's an acceptable contribution.
Yeah, and we'd be happy to perform that function. It's just a matter of staff resources to do that. Yeah.
Yeah, but this is, you're the Ethics Commission. This is your
absolutely.
recommendation. You're there to make sure that this works and that we're fixing a problem that's broken. So
right, and in fact, the Ethics Commission would advocate a database of all sorts of information about contracts, all of the contracts in the city, not just who's bidding on a contract that triggers the ban. So yes, we think that this is definitely an issue to be addressed.
Yeah. Okay.
So the main things I have, the CLA recommendations and the ethics recommendations and the city attorney's advice. I'm trying to mesh right now.
I know.
And so we rely on our CLA, who I think has done a good job with some of these. Just going through the recommendation of the CLA, I would personally support imposing restrictions on bidders who are selected as contractors for that period and not for losing bidders. I understand that point. I think I'd make it 12 instead of 6 months. 12 months doesn't seem too long. Seems to be pretty fair, and I think that's good for public perception.
After the contract is signed.
Signed, yeah, exactly. So just for that 1 year after it's signed. For the winners. The bidders, the second one, the impose restrictions on bidders who are not selected is the same thing. So it's just until that moment's signed. If you're a losing bidder, you can donate from that point on. The third one, that it's $100,000 contracts, I think that's a good threshold. That's where there's council approval anyway. Apply restrictions to principles of the bidder. I don't know how you had that defined, but I do like the Ethics Commission definition. Is that what you were thinking when in the report?
Along those lines, yes.
Yeah.
Just wanted to ensure that we didn't get
I think
into
that's a
too
good
many
list of, either those individuals in charge of that contract or the very top folks in a company. I mean, obviously, if it's, Costco or something, there's going to be a ton of people who work at Costco who happen to want to give money to candidates, and we can't restrict them just because they work there. But those who make decisions, at that high level, it's important. The fifth bullet point, to apply restriction to contributions to committees controlled by a city official, I think is good as well, that you were in unison with. The sixth point, require invitations for bid to include notice of the prohibition and require them to submit an Ethics Commission form certifying, I think is good, and those should be at a central place, I think, in the Ethics Commission. I think that's and I understand nobody has the staff that they need or want right now, but just to keep that, I mean, you keep very well 25 pieces of mail from each of the candidates in election time. It's really just keeping that in one place. It's not going to be too onerous, and it's on them to do it. Excluding them, I don't know how you feel, Ms. Hahn, but I think maybe 1 year is too short, 4 years might be too long. Maybe we say 2 years if they violate the ban.
Oh, yeah.
They can't contract, like a 2-year.
I think that's harsh.
Or we could do 1 year, and then if they ever violate it again, it's 4 years or something like that. You can do like an escalating thing. Want to do that, like 1-4?
I would do 1, 2,
1, 2, 4.
3, 4.
If you by the third time, if you don't know it, why we say 1, 2, 4?
Okay, 1, 2, 4
on violations.
1, 2, 4.
In terms of the years, and then after that, you can never bid again. You continue to. No, I'm just kidding. Although, in an ideal world. Consistency with other sections of the city charter, yes. The only things that are left now that I think we'd have to decide then, one is subcontractors. Mm-hmm. 2 is how do we define the types of contracts. 3, is this just personal donations or is it fundraising as well? And then 4, I had asked for, and I didn't see it reflected in here, but I think we should have something like we have on our donation envelopes or piece of paper where there's a box that says, I'm not currently bidding for a city contract. So when they give a donation to us, they actually have to check that off. So it's yet another piece of record where, I'm not a principal of a firm. I'm not the owner or principal. Yeah, exactly. For this. So I think that should be something we incorporate in. That could be in the enabling ordinance. It doesn't have to be in the charter per se, but I think that's an important piece so that the onus is really on these companies to make that positive assertion. And then the punishment, it sounds like the punishment is on them. And it's not that, trust me, there are plenty of rules that punish us for what we do if we ever step away from the ethics laws, but I wanted not to add yet another burden. If we really make this clear that this is on contractors as it is in Metro and other to make that assertion. I didn't see anything in here that if somebody lied and did this, that somehow the candidates would be fined or punished. Is that correct? Because I would be very remiss to support
we
that.
get fined and punished. We get fined and punished now, even when someone lies about whether or not they, are the same person or same committee, and we get charged for accepting.
No, absolutely.
That happens all the time.
Which is why I don't want to see that here.
It's on us. It's not on them.
Yeah.
And I think that's another reason why the know or has reason to know standard is what the commission advocates at this point. Because if you do have something on a contributor form and there's a checkoff box and they say, no, I am not a contractor, when in fact they really are, then you don't have a reason to know unless you have outside information from, a different way. But based on that why, you don't have information that would hold you accountable in that scenario. You are operating under the assumption that they are telling you the truth.
And I think we could go a step further and actually put in that the enabling ordinance maybe that nothing in here should be construed as, acceptance by a candidate of some sort of guilt because, somebody didn't tell the truth on these forms. I mean, we'll work on the legal language, but just to protect further, I think that's important too. And so on those main 3 things, I mean, in terms of, I guess this is back to the city attorney, so let's work backwards from those last 3, whether it's just personal donations and fundraising, what types of contracts, and whether subcontractors should be involved.
Yeah,
go ahead.
There's another issue too,
Sure, yeah,
in terms of whether it should be an outright contribution ban versus a lower contribution limit.
I think I'd go for the ban. I mean, we already have, with our limits at 500 or 1,000, I can understand in New York, maybe it takes it down to, 10% is what our 100% is, more or less. It's, giving $50. I don't know if a court would find that to be so substantive.
It's based on the cases that I've read, faces a lesser burden for us to demonstrate that it's a closely tailored provision if it's a lower limit as opposed to a ban. Not that it wouldn't be upheld if it's a
questions.
complete
I think that's some other
ban,
people,
but it's
but-
more legally defensible if it's a lower limit.
Nothing like that. We're just- this is us
Okay.
right now.
Okay, let me ask, also under the recommendation 5, exclude approval required by the city attorney or controller. What does that exactly mean? So,
Because the Ethics Commission's recommendation is that the ban be triggered by any contract that requires approval by an elected official, they were very cognizant of making this a realistic and reasonable provision. And those two sections of the charter are requirements that the city attorney's office sign off as to form on every single contract in the city. It also requires the controller to approve payments for contracts and to inspect the quality of the goods and services that are being provided in exchange for that payment. So the Commission's point there is we're not talking about the kinds of approval that only go to overseeing the process, to make sure that the contract itself is legally defensible and that we're getting what we're paying for.
I see.
Those decisions don't
But for
go
instance,
to...
if there was an outside law firm that was bidding, that we could not take, and the city attorney could not take contributions from that law firm.
That's correct. If it were a contract that the city attorney had to approve in a substantive way, meaning he would select the
Okay.
contractor.
All right, and then the other one, this ban, number 6, this ban applies to any city committee controlled by an elected city official or candidate for elected. So
Yes.
if a city council member is running for a statewide office,
That would not be considered, the campaign committee for that statewide office would not be considered a city-controlled committee. So it would be a city committee for someone running for a city
but it would
office.
be controlled by an elected city official.
Yes, and that's,
But it says committee controlled by an elected city official.
any city committee.
Could be a state one.
Oh, any city committee controlled by an elected, or,
Yes.
okay, so it's
Yes.
just city.
Yes.
Okay.
But it would also apply to office holder accounts,
Right.
legal defense funds, and ballot
Right.
measure committees, as the commission proposes it.
Right.
So the city attorney's opinion on subcontractors or not?
Yeah,
It appears to be legally defensible to apply it to subcontractors as a general matter, but it may become overly broad if you're applying it to all contractors, and so we would recommend that there be some limit on which subcontractors you're applying it to. So it's either a percentage of the amount of the contract or a dollar figure, and yeah.
Well, if we had the threshold, would the threshold be the threshold? I mean, if it's 100,000, are you saying that we should go higher than 100,000 potentially with subcontractors? Because then we'd have the situation where you might have a subcontractor who has $1 million subcontractor, a $10 million subcontract that
Right.
doesn't have to declare, and a $100,000 contractor that does. So, I don't know. I guess we could work with the CLA, on trying to find that if we send this forward, get council approval and ask you to draft that. But I
Right.
think I'd like for us to try to include subcontractor and figure out a way to do that. But again, keeping the database at the Ethics Commission, that does put more of an onus on contractors. But as we all know, that's often the modus operandi, as you collect 20 checks from subcontractors, and that's how they raise, even if they couldn't do it themselves. So I think it is an important, if we're going to be genuine about this, I think it's an important piece. So I would include that, and just moving forward, maybe we'll keep it broad, but
Certainly.
But they'd have to be very specific in reporting back to us how that would be implemented. And then in terms of the types of contract, so the types of contracts aren't really in the CLA report per se, is that correct?
I'm sorry, could you repeat
The
that?
types of contracts that would be covered? Did you?
Right, our report recommends contracts that require substantial review, so again, getting past the review by form, or approved as a form, but require actual substantial review by elected city officials, and those that have a total contract value of over $100,000.
So why wouldn't we include something like developers who don't get a contract from the city but have something worth, a discretionary action worth $10 million? I mean, what's the city attorney's opinion on that? Because I had some folks saying, well, if you're going to do that, and I described what I do if I know somebody's a developer in my district, 6 months before, 6 months after, don't, accept donations. But is that run into legal problems?
Well, there are two issues. One's a legal issue, and one is the Ethics Commission had a draft recommendation for how to define generally what types of things we're calling a contract, and it's very broad language. For example, the first word in it is agreement. So arguably, it might apply to development agreements. My understanding in talking with some of our related city entities is that some development agreements do come to the City Council for approval and are in response to requests for proposals or qualifications. And so they might,
Well,
right
if they are
now,
in
they may
response to
technically
RFPs,
be in the draft language, but there is a potential legal issue. 6 years ago when we were looking at this before, there had been a proposal to apply the same type of restriction to certain kinds of development or real estate matters. And at that time, we advised that we thought it needed more study because it's a complicated issue, and
So
identified.
you studied it for 6 years, and what did you come up with?
We haven't been studying it because this council didn't ask us to continue to look at it. But there was also a Ninth Circuit case that gave us some pause, and I don't think that case has gone away at this time. But if you want us to look at it again, we will continue to look at it, and we will have to look at it with regard to the possibility that this might actually, the proposal right now might actually apply to certain development
You said something
agreements.
subtle, though. You said it might apply to some development projects when there's an RFP.
Yeah.
So I want to make sure everybody caught that. You weren't just saying not necessarily any land use decision. You're talking about if there's a plot of land that we're involved in and the city owns or the CRA is involved in. That's different than, do you have opinion about just general, land use decisions? Is that so broad that it would be dangerous legal territory to tread on?
Yes. So there was a Ninth Circuit decision in 1991 that appears to not have been overturned at this point, and it's what it was not actually what it was a recusal requirement on government officials to recuse themselves if they had received a certain level of contributions from this was a water service district, a water service applicant, but not from anybody else. The Ninth Circuit struck down that restriction, finding it to be an impermissible limit on the applicants' water service applicants' First Amendment rights under the Equal Protection Clause because it did not also apply to the people who opposed those applications, such as neighbors or potentially other people with an adverse opinion of those applicants. So at the time that we looked at this before, we were concerned about applying it to these types of real estate matters because we might be required to apply it to the people who oppose such development agreements, and then it becomes a very broad prohibition.
Okay, that's clear.
Would you ever see this being applied to unions under a project labor agreement, perhaps?
That would be something that we have to look at. I know in looking at the cases that have come down recently, there's been some discussion in a couple of cases about whether those particular restrictions could apply to at least collective bargaining agreements, which are a little bit different. And in a couple of scenarios, the courts ruled that they couldn't because they were in conflict with the state's or local entity's labor law. Project labor agreements, I would have to look into that.
Would you look? I'd like to get an answer to that question, because I know we have looked at awarding project labor agreements citywide within CRA projects, at the port, at the airport, and they become, a major entity.
Well, what I would recommend then is, it seems like there's two areas we might need a little bit more definition and specificity on, which is both the subcontracting and the types of contracts area. I think the rest looks good, and I appreciate those questions. I think in an ideal world we go as broad as we can, and some people might call on us, go broader. I'm not interested in passing something that gets struck down though either, and we have experience with both sides of that. But I'm also not interested in doing something symbolic, and I think there's a clear area that people know and understand, which are city contracts, which are RFPs for specific things, where people still have the ability to give. And if we can close that, whether we grab everything else or not, I don't want it more narrow, but to go too wide is also a concern. I appreciate that feedback, not because I wouldn't ideally like to do that, but just like our last meeting, things like Citizens United happen, and you suddenly have to change the law whether you feel strongly about it or not. So I would move that we move that forward to council, and that in council, if the CLA could work to give us maybe a menu of some choices on the subcontracting, the types of contracts, so that we can make those decisions.
And obviously, any law is only worth its ability to be implemented and enforced. And so I am concerned isn't a word. I'm just curious, I guess, particularly how this idea of getting the list of live, bidders and contractors to the candidates and their committees, how that would work. I've suggested it, but I'd like to hear back from you. What would that look like for your office? What would that look like in terms of staffing? What would that look like in terms of how you saw that database really being active? Because I see this as being really kind of a moving target. If things happen quickly in the city, contracts come up quickly, contracts get thrown out quickly. And elections happen quickly, special elections happen quickly. So I, really am curious to see how we see this looking in your department.
Okay, great. We'll give that some thought.
Just to clarify
and I'd answer back on the project labor agreements.
Yeah.
And
I wanted to clarify what your direction was on whether or not this should apply to fundraising or only contributions.
I think that it should be fundraising and contributions. I hear the city attorney's she's already shaking her head about it, which I understand. I would like both sides of that to be given fairly, and I will make sure to afford you the time so that the council can decide whether I'm too far reaching on that or not, or whether we're too far reaching or whatever. But I think it would be both for now, and let's see if we can.
We'll have that information.
And if the worst is that piece gets thrown out, then we're just at least back to having the ban on the contributions itself. So we'll make time for Ethics Commission to report back on what Ms. Hahn said, for the city attorney on that issue to give us both sides, CLA to prepare some recommendations on those last two issues, and for that to council. But we never do that before hearing from the public.
Oh, right.
Yeah,
and obviously this never will apply to independent expenditures, right?
We can't. Yep. The giant loophole.
Yeah.
Robin Gilbert, if you'd like to come forward from the Clean Money Campaign.
Yes, hello, Robin Gilbert. I'm a volunteer with the California Clean Money Campaign, and I coordinate other volunteers in the San Fernando Valley. This item overlaps a little bit with item number 7. They both would improve the transparency of our elections, the city elections. And when I first saw it, I thought, well, isn't this already in effect? It seems like, I don't want to say a no-brainer, but it seems like something that would really is necessary. I'm glad to hear the discussion here. It sounds as though there is a lot of support from the committee and that you're working on the details. So I hope you'll continue to work on that, and then I'll speak later on number 7.
Great. Thank you, and we'll keep your card for that. Angelique Kronheim is next, and then Trent Lang.
Hi, Angelique Kronheim with California Common Cause. We just want to tell you guys we definitely support this measure, and I wanted to thank Council members Garcetti, Krikorian, Koretz, Reyes, and Rosendahl for putting it forward. Thank you.
And now Ms. Hahn, too. Trent Lang.
Hi, Trent Lang, California Clean Money Campaign. We'd also like to thank all the members for putting this forward. This is a very good idea. One thing we'd like to see if it's possible to consider is extending the ban to electioneering expenditures. I don't know if that's possible, but that would be very worth exploring if it is possible.
What do you mean by that?
Theoretically banning contractors from doing large independent expenditures that affect city races, because obviously that's a way that contractors can have a very large effect on campaigns. I don't know whether or not that will fit in with our Supreme Court or not, but if we could explore that, that would be very, very helpful.
We'll see if we can get some city attorney input on that when it comes to the full council too.
Okay, that'd be great.
And Wayne Williams.
Thank you, Councilman, Council. This is really a good idea. I'd even like to see it wrapped in with Councilman Huizar's the package that's coming up next that we're going to be talking about, because it would strengthen both of them. I think this is an important thing to do and the right direction to go to let the public know that the council and certainly the city, should it pass, is committed to cleaning up any form or semblance of propriety provided to money. Thanks.
Thank you very much, Wayne. Appreciate it. That'll close our public comment, and we'll move that forward from committee. If we want to convene now, my co-chair, Mr. Zine, from Personnel Committee, our joint committee meeting of both Rules and Elections and Personnel. Mr. Huizar, did you want to make a comment before, just on the package? Because I know you have to go, and I want to be sensitive to your time as well.
But I know you're taking up some items that the vote by mail, the RCV, and the removing the cap on the matching fund grants. If I could just provide my comments on that, and I know you're going to take those up after your joint personnel committee. Is that appropriate, Mr. President? Mr. President, so I could go ahead and make my comments.
Go ahead.
You
Just before, as we're convening it, Mr. Huizar wanted to speak, though we're going to come back to the actual moving on 5, 6, and 7.
Great, thank you. And so thank you very much, Mr. President. And I'm very eager and interested to see my package move forward to full council. I know, for example, on the ranked choice voting, the city has been studying that over and over and over again. And in fact, the report that was requested by this committee a couple of weeks ago to get more information, the CLA pretty much put the same report back that it's been using for the last 2 years. It's either we principally agree with this ranked choice voting or we do not. But I think a lot of the questions that I've been hearing are mostly on the implementation piece. A lot of folks are telling me that they agree with it. It's just a matter of, can we implement ranked choice voting or not in the city of Los Angeles? And I believe we can. We have some time between now and the council adopts it to take care of any of the questions we have. Plus, if we look at this, the county will not be ready with its machinery, with its computers, with its technology until 2015 to actually implement this. So we have some time to educate. We have some time to talk to the county about what we would like to see. Finally, the last point on ranked choice voting that I like to address is that the CLRA report mentioned that this will cost us $40 million. In fact, the county is moving forward with changing its voting equipment anyhow. It's going to happen. They're going to invest $40 million in making this possible. And in fact, it might not even be county money, it may be federal money. It will not cost the city. It is only going to save us money. For the county to implement a ranked choice voting, I read an estimate that's going to cost anywhere between $400,000 to $800,000. And that is something that I think, if it does come from the city, we're going to save in the end by not having so many elections. So hopefully we can move forward with that. I think that is ripe, and we could work out the minor details as we move forward. Finally, on the vote by mail, there's some question as to whether that will save us money or not. There's some question about whether we can move forward at this time. My belief is that if we give the clerk sufficient latitude to decide how we move forward and when we move forward, we will be able to accomplish this, because there is some concern right now whether the clerk's office has sufficient resources to make it possible. However, we look for a special election, upcoming special election, see how that works, get the data, see if there are any problems. We will learn a lot, and hopefully the results will be the same as in Oregon. in other places that have implemented full vote by mail, that in fact it has raised voter participation, and that in fact people are comfortable with it, and then in fact you're drawing new voters to vote, and then in fact you are going to save money. So that's another item that I know we've discussed, not as intently as ranked choice voting, but I think that is also ripe to move forward with today to full council. Finally, on removing the cap on the matching matching funds, I have some proposals on changing some language that was submitted by the city attorney, and as many of you know, this is the first step in moving toward fully publicly financed campaigns in the city of Los Angeles. I strongly believe in public financing of campaigns. We can't jump into it as quickly as I would like, but this is a first and very important step in moving in that direction, and hopefully we will see that move forward too. I understand since that has financial implications, it will also go to Budget and Finance Committee, so hopefully we could see those items move to full council. That's my comments, Mr. President and Committee Chair, and thank you very much.
Thank you, Mr. Huizar, and thank you for your good work on this and for making the time to be here. We appreciate it, and we will be taking those up after our joint committee. So we'll now convene the joint committee, and we do have a lot of cards on that as well, so sit tight, and thank everybody for their patience on 5, 6, and 7. We have 1, 2, 3, and 4. I know Mr. Rosendahl had wanted to say something on number 1 and 2 and had to leave. I've talked to Mr. Zine. Again, we wanted to put these forward, and there's issues of making sure that we have some parallel tracks on this because the Rules and Elections Committee doesn't have jurisdiction over something not on the ballot. Personnel will be taking that up swiftly in a Personnel Committee meeting, but we can certainly talk about any of the issues today. But I think 1 and 2 we won't be putting on the ballot or moving forward for action from the Rules and Elections Committee today. But 3 and 4 are important ones. So, Mr. Co-Chair, you want to take over and start with number 3, or anything about 1 and 2? Yeah.
On 1 and 2, they're going back to personnel?
Well, they're in personnel already. Rules and Elections doesn't have any jurisdiction over it because it's
if we can do a joint meeting on those?
They have been calendared. They have.
Yeah.
I mean, but if we can do a budget and finance and
Budget and Finance, yeah, that would be good to do it. So you guys can. Is his microphone on? Yeah, it is. It should be already on.
Hello. All right, so
we should go to 3.
We want to move 1 and 2 just to Personnel Committee?
Sure.
Mr.
Why did you say we're not taking
Correct.
action on
We don't have jurisdiction.
There's no jurisdiction, I understand, the joint committee.
We'll do a joint budget.
Just to clarify, civilian changes don't go to the ballot.
right.
It's the reason why we have joint on the sworn, the fire and police pension issues is because that has to go by charter to the ballot for charter change since it's in the charter. So that's what we're considering, at least from the Rules and Election side. Personnel has jurisdiction over both civilian and...
Mr. Parks and I will take items 1 and 2 into the Personnel, Budget, and Finance Committee. We'll do a joint committee on 1 and 2, and we will select a date that's convenient and timely to move those items into... if there's any comments on 1 and 2, we will listen to the folks now. Elizabeth Ralston on 1 and 2. Elizabeth Ralston, you can comment on both, please, ma'am.
Okay. My name is Elizabeth Ralston, and I represent the League of Women Voters of Los Angeles. And the League has a position arrived at through study and member consensus, which supports almost all of the elements of the first motion. The League believes that reform of both city pension systems is a key factor in attempting to deal with the city's long-term structural deficit. Our preference for civilian employees would be for increasing the retirement age to 67, which is the retirement age.
The age to increase to what?
For civilian employees would be to increase the retirement age to 67.
67? Okay.
Yeah, for LACERS employees.
Okay.
And with retirees, with members being given the option to retire earlier at actuarially reduced benefits. And our preference would be for keeping the COLA in line with the COLAs for fire and police.
Yeah, I know it is.
The League also supports a reduction in the retirement factor from 2.16 to 2% per year of employment, and this is what has been proposed by the CAO for the first 20 years for fire and police. But we encourage the council to evaluate the cost savings from each element of this proposal. Do I have another minute for
Yes, go
number
ahead.
2? Okay, for number 2, we would strongly support the council having the opportunity to evaluate the cost savings from each of the design elements that are mentioned in this motion. And one element that we would like to bring to light, which is not included, is eliminating the subsidy and lacers for the government service buyback. This provision allows employees who have worked for another government agency with which the city does not have reciprocity, and that, for example, would be the federal government, for example, to buy service credit for the time they spent working in that other government agency. Fire and police has the same provision, but with fire and police, the employee has to pay the full actuarial cost of the benefit. For lacers, the employee does not, and in effect, they're receiving a subsidy worth tens of thousands of dollars. And this seems to be relatively easy savings to implement, so we would suggest that be considered as well. Thank you a lot.
Okay, thank you very much. No other comments from the public on number 1 or 2?
Remind us, I mean, if you guys are a personnel committee, you can act on that. We would have to be here as interested observers, you know.
We'll push it to Budget and Finance and Personnel Committee.
Okay, all right.
So let's take item number 3, and then I'd say we have Mr. Parks here, Mr. Zine, and Mr. Koretz, I know was here. Is Mr. Koretz still here?
Yes, he's here.
And we have a quorum
can't see him.
of rules and
Hiding.
elections right here. We have 2 cards on this too, if you...
All right. So on 3 and 4, we have Elizabeth Ralston, 3 and 4? I'm sorry, number 3. Number 3.
Are we taking up 4 yet?
We're taking number 3.
Okay.
And then Gary Tobin.
The League of Women Voters welcomes the proposal from the CA's office. The reforms in this proposal are all ones that the League has supported. Our preference would have been for lowering the maximum pension benefit to somewhere in the 75 to 80% range, and this could be achieved by making the retirement factor 3% for each of the years from the 21st to the 33rd year of employment. The League would also favor raising the retirement age for full employment for sworn employees to 55. All in all, however, these changes that the COs have proposed are a welcome and necessary step towards reducing the city's structural deficit. And we strongly urge the committee and council to move quickly so that, that there will be a measure on the March ballot. We believe the time to act is now. Thanks a lot.
Thank you. Gary Tobin or Beverly Kenworth? Standing in for Gary Tobin.
Good afternoon, council members. Beverly Kenworthy with the LA Area Chamber of Commerce, speaking on behalf of Gary Tobin, President and CEO of the Chamber of Commerce. The Chamber of Commerce appreciates the work that the council has done in making these tough decisions on pension reform. We still feel there's a ways to go to make, the substantive changes that are going to keep the city solvent for years to come. And we look forward to continue working with you on those, and we urge you to continue this work and make the difficult decisions that need to be made. Thank you.
Thank you. Okay, the
Pick up 3 first.
number 3, Mr. Parks.
Do we have CAO here on this one? Want to come forward and just we'll hear their report?
Okay, go ahead, please.
Yes, good afternoon. My name is Thomas Simonovsky from the Office of the CAO. And basically what we have here before you is a pension reform item for the fire and police pension system. This is for our sworn members of the police and fire department members. And, we've kind of looked at different types of studies. We've, met with unions that represent these members, and, we've taken their input in consideration, and we've consulted with our actuary to conduct various studies.
I'm listening.
Oh, sorry.
We're making sure.
No, they're men, they
Trying to
can't
get all the documents
multitask.
together.
Only women can.
Okay, page 4. Oh, sorry. Okay. Hold on, just one second. Gotcha. Okay, go ahead, please. Sorry.
Thomas, go ahead.
Okay, thank you. So basically, this is for our Los Angeles Fire and Police Pension System, which pertains to our sworn fire and police officers that are members of LAFD and LAPD. And we basically sat down with the unions that represent these members. We received their input, and we put together various actuarial studies. Those studies are contained in the report, and we believe that the recommended new tier here is basically going to result in some significant cost savings for new hires, as well as make sure that it retains our recruitment and retention efforts. So it's kind of a delicate balance, but at the same time, we think it's something that will result in some savings for the city. When we look at hiring for a new tier, for new members, that's something that we believe the city will more than likely be doing, at least to an attrition level. And so, because of that, we calculate that over a 10-year period at attrition, we'd be saving approximately $150 million. And over a 30-year period, with new hires, for every 1,000 new hires during a 30-year period, we'd be saving about $173 million. That's based on the results of the actuarial studies where we took the data and we made some analysis.
Just a point of information on that, do you have any projection of how many new hires based on demographics we will make in 30 years?
It's difficult to do that. That's why we had to break it down by 1,000. So it's kind of hard.
But we can't save, just to be clear, we can't save more than the number of employees we have, right? It doesn't go on 1,000 forever. If we have, 15,000 sworn, once we get 15,000, you can't continue to save above and beyond, right?
There's a good chance that in the next 30 years we would virtually have a new workforce. So that savings will continue to generate and result in some significant cost savings for the city.
So how many sworn employees do we have right now? If we kept steady for the next 30 years, which we probably won't, but let's say if we kept steady and replaced all of them, how many is that?
Well, right now there's approximately 14,000 active members.
9,963 active.
99.
Now, those in pension, there's 9,963 on the books as active personnel working. When you include the retirees, what's our number?
Police, that's fine.
Well, the police and fire.
The retirees, I believe, is approximately 12 to 13,000.
Of police and fire?
Yes.
12 or 13,000. But they break down to Article 17, 18, 35. Do we have a breakdown of the different categories, the different pension plans? Because I understand there's 4 or 5 different plans.
Well, right now, there are 5 different tiers, and so we'd be recommending a tier 6, as we call it. And each of those 5 tiers are, they have a little bit of differences in terms of how the benefit designs are set up. Tier 5 is the current tier that currently new hires would go into. And so, with this recommendation, we'd be, closing off that tier and establishing a tier 6.
Now, how many do we have in the other tiers, the 17, 18, 35?
I can actually get that data here for you if you hold on for just a moment. But tier 5 is by far the biggest tier in terms of active members.
And that's been in place 10 years?
It's been in place for about 8 years. In 2002 is when it first was enacted, and that was a result of a charter ballot back in 2001.
Did Mayor Reardon authorize that?
Yes, that's correct. That was part of Reardon's administration. That sort of got the ball rolling.
And
on
the plan they were talking about, Tier 6, I know the mayor had a news conference regarding pension changes. Did this generate out of the mayor's office?
Well, we actually have been briefing the EERC on pension reform, and this has probably been going on for at least a year now. Actually more than a year, probably more like a year and a half. And so we've been trying to report consistently on different plan designs to get authorization on proceeding.
So it generated out of EERC?
That's correct.
Okay.
Yeah. Okay, so if I start with Tier 1, right now there are no longer any active members in Tier 1.
That's Article 17?
Yes.
Article 17?
Yes.
So they've all passed away?
No, well, active members have all retired, and basically there's about 153 retired members of that tier.
Then there's survivors.
There are survivors. There's about 499 survivors and 157 disabled members of Tier 1. Tier 2 has about 167 active members. There are 5,528 retired members, 1,788 disabled members, and 1,764 survivors.
Okay.
Tier 3 has 977 active members.
Now, when you say active,
that means that they're currently in the workforce working as either, a sworn police officer or a sworn firefighter.
But how many years would they have in service?
Well, for Tier 3, the average service is about 15 years.
Okay.
And their average age is about 43.
Okay.
Yeah. Now, there's also about 56, they call them vested, terminated members. Those are people that have enough years to vest into the system, but they have since, left city service. And once they reach the appropriate retirement age, then they can, come back and get their pension. There are 116 retired members of Tier 3, 238 disabled members, and 73 survivors.
Now, when you say disabled members, they're still drawing a pension?
They're getting a pension because they've been approved to receive a disability retirement.
And that disabled pension would be tax-free pension? Tax-free pension versus taxable?
I believe so. Yes, that's correct.
Okay.
Yeah. And then Tier 4 has 435 active members, 106 retired members, 40 disability retirements, and 3 beneficiaries. And Tier 5, which is our current tier, has 12,108 active members, 5 vested members, 1,708 retired members, 79 disability retirements, and 72 beneficiaries.
Okay.
And I just want to point out that does not include the Port Police officers, because back in 2006 they also became eligible to join Tier 5, and there's 115 active Port Police officers that are part of Tier 5, 1 retired member, 2 disability retirements, and no beneficiaries.
Okay. So the proposal that was brought out of EERC that the mayor had a news conference on is the one you're bringing forward now?
Yes, it went to EERC. It's gone to EERC periodically, but the last final approval that we received was last week on October 12th.
And there's a question that came up from the representative from the league, as well as a motion that was introduced today, and you made a comment, you sat down with them.
Yes.
Was that considered a negotiation, a meet and confer, a meet and consult? How was that defined?
Well, we've been very careful to make sure that when we do sit down with the unions that, from our perspective, it's a meet and discuss or a meet and consult, that it is not a meet and confer, a mandatory subject of bargaining. And obviously we've had some differences in that from that perspective. But at the end of the day, we feel like we have gotten 100% cooperation from the labor unions that represent these members. And, we asked for feedback. They gave us good feedback. They gave us some good suggestions. And so we went ahead and we costed out actuarial studies, including their feedback. And before you today is the result of that cooperation that we've been able to attain with labor.
So the retirement benefit factors, et cetera, the current Tier 5 and the proposed, those have been approved by both the police and fire unions?
I'm not sure if they have approved anything, but at this point, they have not informed us that they are not supporting, this new tier. Because this is something that, we've been very careful not to, engage in a formal negotiation, and, sort of not engage in a mandatory subject of bargaining. We have not asked to come up with some type of signed agreement. But at this point, we have every reason to believe that, we've got their cooperation and they have not told us that they are not supporting this recommendation.
And is this page been distributed on the proposal? Has that been distributed to the public?
Yes, the report that we released on Friday of last week is a public report.
Okay.
And I believe there's been a number of newspaper articles. It's been in the media. There was I believe, a press release earlier this week from the mayor's office. So it is a public report. That's correct.
Okay, because we don't have any other cards on.
We do.
We do.
Oh, no, sorry, on 4.
Okay, well, this is number 3. Yeah. The other issue on this, which I know the police and fire have to go to the voters on a charter change.
That's correct. This does require a charter amendment, and so we would have to get it on the ballot. And if we're targeting the March 2011 election, then the final deadline to instruct the city attorney for a resolution would be November 3rd of this year.
This November 3rd. Also, it states the Water and Power has a separate retirement plan for its employees. Does that also have to go on the ballot?
If it is the will of the council to pursue that, then yes. If we were authorized to move in that manner, to make some changes over at DWP with their retirement board, in terms of the jurisdiction, then it would require a charter amendment, because right now the way the charter reads, it basically sets up the department, the Board of Water and Power Commissioners. They are the quote-unquote plan sponsor, and they basically can set the benefits for the DWP retirement plan.
So there's 3 plans. There's LACERS for civilian, police and fire, and water and power.
That's correct.
So we're discussing the LACER for all civilian employees, excluding water and power, and police and fire. And if we're going to do pension reform, which comes out of the dollars of the taxpayers, has there been any movement with the Water and Power Commission or general manager, acting general manager, to do any pension modification for water and power employees?
To our knowledge,
since we're running out of time,
with DWP, we're not aware of any current efforts to make any changes to their pension plan. Approximately in January of this year, we did ask to sit down with the unions and just kind of, present a proposal to let them, look at it and give us some feedback. That didn't go too well. But at the end of the day, we don't really have any authority to, any current authority, the council does not, in order to make any changes. The DWP doesn't get, tax money, they get ratepayer funding, but it still comes from the residents of Los Angeles.
Well, the ratepayers pay for the water, ratepayers pay for the power, and out of that come the salaries, benefits, and pension
That's
for
correct.
the employees of the water power.
That's correct. And I did want to point out that DWP, they recently had their evaluation performed by the actuary. It came out for this latest 2010-11 fiscal year. And the results of that valuation, their contributions increased significantly. They went up by about 12%. The prior year, it was about 26%, and now it's increased to 38%, and that's 38% of payroll. That's only on the pension side. It does not include any healthcare-related costs. And so, those are significant increases to their plan.
And those increases are paid for by the consumers who pay for the water
By the
power.
ratepayers.
Okay.
Yeah. Now, there's also other ways that the system gets funded. The investment gains that the system receives. So when they get a return on their investment, then a portion of that will also go towards funding the plan. And then there's also employee contributions that are go into the plan that are also used to help fund it.
And on the new plan proposed for police and fire, it talks about health contribution, employee health contribution, which is not currently exist on the Tier 5. Is there a vested interest? Is there a necessity to have a meet and confer on that, or can that also be part of the meet and discuss?
Well, part of the reason why this plan saves the city, some money is because the employee contribution increases. It increases to a total of 11%, 2% of which is towards retiree health care. And, we're not recommending to change the actual way that the healthcare benefit is provided to the employee. So for example, right now under Tier 5, the maximum healthcare subsidy is attained after putting in 25 years of service and reaching age 55. That would still be the same. The subsidy amount would still be set by the Fire and Police Pensions Board, and that increase is capped at 7% up to 7% per year. So this design does not modify the way that healthcare benefit is provided for.
Okay. And the plan that appears, the proposal, the retirement benefit factors, the other plan design, just to clarify and to verify, that has been, to your understanding, supported by both the police representatives and the fire representatives? Well, I'm going to have them speak, but I want to verify it with you before I do that.
Yeah, it's our understanding that at this point, they have not disputed this recommendation.
Okay. Mr. Parks?
Let me just ask, on the three pensions, the police, fire, and the DWP and the LACER, have they all had recent actuarial studies?
The only one that's been released so far, to our knowledge, is the DWP. The LACERs and fire and police pensions valuations are still being worked on by the actuary, and the latest information that I heard was that they'll be available, I believe, in November.
Is that required to have the actuarial before it goes on the ballot?
We definitely need to have an actuarial study whenever we do a new benefit tier for retirement purposes, and so we've satisfied that with the fire and police pensions recommendation that we have before you today. We have also done actuarial studies for a LACER's pension reform as well, and that is part of the requirements in order to get the costs.
We're sure that DWP has done one also?
For DWP, we have not done an actuarial study for pension reform. No, we have not done that. The study that I'm referring to is the annual evaluation that the actuary does in order to come up with the required contribution rate to fund the plan.
Are they in the process of doing one?
DWP? Not to my knowledge. We're not aware of any pension reform efforts over at DWP.
But in the CAO report in page 4, it talks about the prospects of putting it on the ballot to basically change the sponsorship. Would you need the actuarial study before you made the change in the sponsorship?
No, it's
Okay, you
not
could do
an
the
understanding.
sponsorship separate, and then later end up dealing with the plan changes.
Correct. Yes, that's correct.
Okay. Then let me ask you, one of the things that has been very confusing to a lot of people after the mayor's news conference was that just where this plan came from. There was even discussions as whether it was watered down, and I don't think people understood it came out of the actual actuarial study actually identified it being the most cost-effective of the plans. Could you kind of explain?
Sure, definitely. Yeah, we actually initially thought that going back to a prior tier, Tier 4, was actually going to result in some significant cost savings. Our goal was to come up with a 20% savings on the normal pension cost. And so, we had the actuary go ahead and do a reversion to Tier 4. And Tier 4 basically has a benefit cap of 70%. So if you put in 30 years of service, you're going to cap out at 70%. Now, to that, we added a minimum age, because Tier 4 doesn't have a minimum age. And so we thought that was something that would be, important with pension reform. And so we came up with a minimum age of 50, and we also included a retiree health contribution of 2%. And we went ahead and we got the results back, and the savings target actually did hit. We did hit a 20% savings target. Now, we also had additional input from our labor unions that represent these members, and they also had provided some insight. And so we went back to the actuary, and we had the actuary, do another analysis. They did 6 additional studies, and they looked at a way to preserve the current 90% at 33 years benefit level in a way where it actually ended up saving more money. And so, because of those results, because the savings was actually a little bit more than going back to a Tier 4, and because, with this type of benefit level sustainability, we felt that it would be beneficial, since we would continue to be able to recruit and retain qualified applicants to come work to the city as a firefighter or a police officer.
And so I think it's important for the public to know what's being proposed didn't just come out of the CAO's office or from the police union, but actually an independent assessment created these numbers.
Correct.
Okay. Now, the other thing that we've been asked is, and I always get them confused, define one or the other, but did we have a actuarial done on a 401k issue?
For the sworn pensions tier, we did not.
Okay. Now, but we did do something on a hybrid for lacers or something.
We basically have looked at a hybrid version for lacers, and we've also looked at a defined contribution plan, which is basically like a 401k for lasers.
Okay. Now, is that being intended to be looked at for the upcoming ordinance as an option, or is that been put aside because of the cost?
Well, as you'll see when we release our report on Lacer's pension reform, the defined benefits plan that we had costed out, that actually ends up being the most cost-effective for the city out of the 3 plans that we had costed out by the actuary.
Okay, and that report is forthcoming?
Yes.
Okay. And then in dealing with the current pensions that go before the board, I think there's a motion in file somewhere that talked also about membership on the different pension plans. Is that something that would have to be by charter, or can that be done by ordinance?
Membership?
As far as
the board members?
Board members.
That would require a charter amendment.
So we'd have to have that orchestrated for fire police, as to what and how that would be administered as part of the charter language?
At this point, I don't believe we have completed any analysis on looking at that matter. But if we were going to make any changes, then it would need to be on a ballot, because it would require a charter amendment.
Just as flexibility, would it be available to us to have the membership of the boards done by ordinance and the plan as part of the charter, or do you need both?
I'm not really sure. I'm not sure if that would be more flexible or not. We'd have to take a look at that and report back.
Okay, but the plan in approving the CAO's report, we're talking about putting the fire police on the charter with this plan. And then our assumption is that the administration of the plan will continue as it is.
Yeah, for this plan, we would definitely have to modify the charter to sort of include the skeleton, and then all the details would go in the admin code. That's consistent with what we did with Tier 5 when Tier 5 became implemented back in 2002. And we believe having that flexibility is something that is beneficial to the city.
Tier yet.
Mr. Parker. Mr. Miller. Mr. Soundman.
In answer to your question, if what you're asking about is well, could the council put on the ballot a charter amendment to allow the composition of the board be set by ordinance?
Yes, that's what I was asking.
I would suppose the answer to that question is, could you? Yes, you could. Again, whether how that would be perceived, but I don't see any reason why you would be prohibited to do that. But there are no other commissions that I can recall that you set the commission appointment by ordinance. Most of them are set in the charter.
Yeah, because I remember there were some motions a while back that talked about the configuration of the boards and how they should be reconsidered. So that's what I wanted to find out. Is that something we'd have to finalize as part of the charter issues, that it has to be before the council by November the 3rd? Or is that something that can be done at a later time as you get the plan approved for the new pension?
Mary Jo Kerwin of the City Attorney's Office. I didn't know that issue was going to come up, but my recollection is that the state constitution, as amended in Prop 162, requires changes in board composition to be approved by the voters.
Okay. Well, that answers it. Thank you. Let me ask another thing. There was a proposal a while back about whether the city should consider the merging of the administration of the pension plans. Would that have to be charter mandated, or is that ordinance mandated? There was a proposal that talked about the potential of saving millions of dollars if the pension plans administration was merged.
This is all put together, established in the current charter, so it couldn't be changed without a charter change.
So we could merge the administrations of the pensions without changing the charter?
No, you couldn't merge them without, that would require a charter change.
You'd have to have a charter change.
The current structure is established in the charter.
Okay, so all of that would have to be done as part of the proposal that's moving forward.
Now, definitely to change, the board makeup, composition, all of that would have to be. There was also some discussion about working together on investments and using co-managers, and there are certain things that could be done without a charter change, but you could not merge the two, you could not recreate the boards, none of that could be done without a charter change.
Now, on Lacers, because it's ordinance, part of that ordinance can change the composition of the board?
No, you just have the authority to modify benefits by ordinance.
Right. Okay, so all of it would have to go charter. Correct. For all three plans. Okay. The only thing I'd ask is that in the CAO report on October 15th, they discussed water and power as being moving forward on the sponsorship, and I just want to make sure that we address that as a part of that proposal, what we need to put that on the ballot for June 3rd, for March 8th, I guess it is. So we'd have to have it before council by June? We'd have to have it before council by June, is it June 3rd?
I'm sorry, for the March election
March.
of next year? Yeah, the council would have to instruct the city attorney to draft an amendment by November 3rd of
November
this year.
3rd.
In essence, in order to move control of benefits from the DBP board to the city
So
council.
we call that sponsorship, I guess.
Sponsorship.
Okay. So the thing is that if we're going to go forward on pension reform, it would seem like we do all of them at one time, as opposed to having one left out or deal with it later.
You mean all three plans, police, fire, and laser, and water and power? But it sounds like there's been nothing done with the Department of Water and Power
I know,
on
but
the
that's-
pension modification.
There's no authority for council to...
Is there authority with the mayor? Or is the
it's
authority
it's the
strictly
Board of
with the
Water and
commission?
Power Commissioners.
Pardon?
It's the Board of Water and Power Commissioners. That's the body that would enact changes to...
And there's been no movement by the Department of Water and Power?
To our knowledge, there has not.
Mr. Miller? Yeah.
Well, in the discussion, the reciprocity discussion, the representatives from Water and Power testified that no, they were not considering changes in the benefit structures on their pensions at this time. And nothing specific. They're aware, they said they're aware they need to look at it, but there are no, they testified there are no specific changes that they're looking at.
But I think there's two issues. It appears from the CAO's report that you can put on the charter the sponsorship issue.
Yes.
Okay, that's the issue that then gives you the ability to then look at the plan. But there is no process at this time of DWP or its commission looking at the plan. But the issue in the report is saying, put on the charter the sponsorship. We can do that without the actions of the DWP or its board.
Yes.
Correct. Okay. So if council, theoretically, if this went forward and the voters approved an amendment to bring the jurisdiction to council, then at that point you'd have the authority to enact changes in their pension system.
And how does the plan that you've proposed on the police and fire compare to other plans in the state for other police and fire agencies, CalPERS, or other jurisdictions that have their own pension for police and fire?
Well, it's our understanding that the state recently negotiated agreements with some of their police and fire units, and we believe that they kept their 90% pension benefits. They increased contributions to 10% for active members. The active members were paying about 5%. And so they did increase the contributions to 10%. They pretty much doubled it. Now, one thing that's sort of unique about pensions is if you have a vested pension right, then if you're going to make any changes to those vested pension rights, then you have to provide a comparable advantage. And so as part of the state deal, when they did negotiate to change the active member contributions, they also negotiated pay increases about a year and a half from the effective date of those agreements. So at some point, the top pay step is going to increase by an equivalent percentage.
So when you say 5% to 10%, that 10% is based on their
salary.
So whatever they're making, 10% is going to the pension fund, which used to be 5%.
Correct.
Now, do you find that other than the CalPERS with their public safety, San Diego and other parts of the state, are they all moving towards modification on pensions?
There are other jurisdictions that are looking at making some changes. I know that San Francisco has an initiative on the ballot for November, and that was actually driven by an employee of the city county. And that's going to look to increase contributions potentially. San Jose is looking at changing their charter so that way they can have the ability to go forward with implementing a new tier. And then San Diego also has a measure that I believe is going to go on the ballot in November as well.
So the mood throughout the state of California with public safety is to modify the pension plans from where they currently are.
That's something that we are seeing, and we expect that it will continue to be like that. because the issues with pensions these days, have to do with the contributions that cities and counties have to, and states have to pay, and really there's not a lot of resources in order to make sure that those payments are made.
Honestly,
So some reform has to occur.
Mr. Koretz?
Well, you've probably asked 99% of the questions that I might have, but...
They asked 115%, actually.
I'll ask a couple, though. One is you've looked at other cities and what's being proposed. What are the kinds of savings that cities like San Diego would achieve compared to what we're talking about? Are we in the same ballpark? Are they asking for greater savings from their unions? How's that playing out? Or have you not analyzed them carefully?
We haven't really been able to do a very thorough analysis. The one that we're probably most familiar with is with the state, and sort of theoretically what's happened is they've been able to get an increase in the member contribution for current employees, but then a year and a half down the road, the top salary step is going to increase by that same amount. So it's almost kind of like a wash. You're increasing it by 5% on one end, but then you're providing an additional salary increase of that same amount on another end. So from that perspective, we're kind of not really sure what the savings would be.
I was going to say, I followed that from a distance. How was it advantageous for the state? Did it just help them get through one budget year and leave them with a bigger hole the following year?
I'm not sure if it'll leave them with a bigger hole, but in short term, it'll inject some additional funding into the plan, since they are going to receive, they're going to double the member contribution. But on the back end, they'll have to pay more for salaries in order to get around this comparable advantage requirement.
Does that same idea, is there any way in which that would be helpful to us if we did the same, and are we looking at that?
It's something that I think, keep in mind, this recommendation here is for new hires only. It's not impacting active members. Any changes to active members would require meet and confer negotiations, and we would be bound by the vested pension benefit laws. So that's something that we would have to, sit down and work out details with the unions. We also would need to, get bargaining instructions from the ERC in order to, get our direction in terms of how to proceed.
And I'm not 100% clear on the process. I know we have a recommendation for us to vote to put something on the ballot, but we have something that we're discussing that hasn't been fully agreed to. So how do we have to approve a final agreement now, even though there isn't one? How's the process work?
Our position is that this does not require an agreement with labor, that we have consulted with them, and we've engaged in good faith discussions and collaboration. Now, of course, we would we're very hopeful that they will support this. We have every reason to believe at this point that they are not against it, and basically we're presenting it to council for consideration to put on the ballot.
One would assume that by the time we actually meet that deadline and put it on the ballot, there would be a general agreement, because from the obvious political perspective, I think if firefighters and police oppose a ballot initiative like this, it fails. So clearly there needs to be an agreement, whether it needs to be, as a practical matter, met and conferred. If they oppose it going in, it's a waste of our time.
Yeah. We'd like for them to be on the same page as we are, no doubt about that.
So I assume we're at least optimistic that that'll be the case.
Yes.
Well, I spy a couple representatives of fire and police union. I don't know if the police union representative is still here, but Mr. McCosker, do you want to come forward and just give us some general comments? Mr. Repovich, there he is.
Why don't you gentlemen come forward on this matter?
Thank you. Thanks for the opportunity. Pat McCosker, President of United Firefighters. You know, we did allege right from the beginning that this is meet and confer, that we should be met and conferred with properly before anything goes on the ballot like this. But I will say that Tom is right. They've consulted with us. They've collaborated and cooperated with us throughout. And really the point of the whole exercise is to get that kind of cooperation and in the end, hopefully to come up with something that's fair and balanced and good for both sides. I think that's what's happened here, quite frankly. You know, we want to help. We understand the fiscal crisis. We understand the hue and cry nationwide for pension reform. We also understand, by the way, that our pension system is one of the very healthiest in the nation, that our folks have done a great job managing the funds, and the CIO's office does a great job overall in this city. So, you know, it's a balancing act here. Quite frankly, we think that what this is, as long as it doesn't change, and the devil's in the details, and that's what I would ask of you and your colleagues in the council, as long as it doesn't change for the worse, and perhaps there are rooms for improvement in it, that what ultimately goes on the ballot is fair and balanced and accomplishes our goal. What we like about it is for those that work a full career on the police or fire department will be entitled still to a full pension. And we like that firefighters and police officers will be helping with the problem of retiree health care, you know, something that the cost of has doubled over the last decade or so. And we're actually looking at that regarding active members as well. So on the whole, I would say we've gotten good cooperation and collaboration, and it's something that we're likely to support in the end. Thanks.
Mr. Repovich.
Hi, good afternoon. We're a little bit different position than firefighters. We conceptually agree that something should be done. We're collaborating as best we can with the CAO on this issue. In fact, they're meeting right now with the CAO. We sent out a letter about 1 month ago expressing the need and seriousness of the city to take this issue serious, as in make it a meet and confer. We didn't hear back from anybody. Nobody changed that. We do firmly believe there should be a meet and confer. Saying all that, we are collaborating as best we can to try to come up with something that we can conceptually agree to. But we're not there. And as Pat said, yes, it's the devil's in the details, but I can't even say conceptually we're there. We've offered and done as best we could to put stuff on the table to make it work, but we're in a time crunch now. Everybody wants to get this on the ballot, and this is stuff that could have been done months ago in a meet and confer more effectively. I agree with Councilman Koretz. This is not something you want to go to the ballot and not have conceptually everybody on the same page. Yes, there is a movement afoot across the state to do something with pension reform, but it's certainly not something you want to go into with any kind of opposition. Everybody needs to feel good and prudent about what conceptually they come up with and what details are agreed to in order to be successful. Remember, the pension system came about for reasons, and that all of a sudden we just come along and say, let's just jump on the headlines and start doing pension reform just because it's the hot thing to do is not necessarily the right thing to do. So the way that we go about this is critical. If it takes more time to get to where we need to get, let's take more time. But conceptually, I agree with the CAO. We do, and we are working diligently to try to come up with an agreement that everybody will be okay with, and that it's prudent for our membership and for the city.
Thank you. Thank you. I was, Mr.
Okay. Something real quick, or you want to go?
I just want to say that looking at the current Tier 5 and the proposal, the retirement benefit factor on Tier 5 proposed minor modification. When I look at maximum retirement allowance on Tier 5, 90%, proposed 90%. Minimum retirement age on current 50 years of age, proposed 50. And when I look at the different categories, it's going to be a savings in the long run. But I don't see a dramatic change because there was talk about lowering it from 90% to 70%, et cetera. And I know there's some factors or some individuals that believe the retirement age should be increased, but when you're looking at retirement age of police officers and firefighters into their mid-60s, there becomes a safety hazard for a variety of reasons. So when I'm looking at this, and I hope everyone's had a chance to look at what's been designed, it is going to be a cost savings, but it's not a dramatic shift, which I don't believe it's a dramatic shift as a detriment to recruitment and retention of our fire and police officers. Mr. Garcetti?
Yeah, thank you, and thank you to both the representatives of our two unions, both of whom I consider friends, both professionally and personally. And I want to be clear that I'm sympathetic to some of the pace issues, and have brought those up myself, and I've appreciated being able to meet with you guys to be able to push this along. I do also want to state, though, that there's not headline chasing here. I mean, we had the presentation of our financial status report here, and I agree that we're well funded today. It's because we have been good from our general fund. And if you look at the projection, this is police and fire right here. I think this year we contributed, how much was in this year? Because it goes to next year, it's like 400.
400.
It's about 400, goes to 450, 515, about 600, 650, 700 in the next 4 or 5 years. So for us to stay as good as we are, we'd have to do that, and we'd have to figure out what in the city we're going to cut, or what taxes we're going to get, which I don't think any of us see a lot of new taxes coming along, or an economy that robustly coming back. We have to figure out how we pay for that. So that's why it's important. We also have to, eyes wide open though, which I've said is, we're not going to close those huge numbers with pension reform right now. That's really about the next 30 years. But what it does do is it sets up whoever is the next generation of folks around this horseshoe who didn't inherit that from the last generation, that they one day won't be in the position saying in 2040, what the hell were they thinking? We have to be responsible for the next generation in a way that isn't, I think you're right, Mr. Zine. When you look at the difference, moving the employer cost of payroll from 22.5% today to what would be about projected at 17.5%, that's still a very generous subsidy. It's one that I think, as we look at the civilian and DWP subsidies as well, is pretty tough to find out there other places in the world. And that's why I do appreciate your willingness to work on this, because I think there is a recognition in our unions, certainly by the general public, and I think by our policymakers, that it isn't sustainable. But we shouldn't pat ourselves on the back that we're going to close a $319 million deficit next year through pension reform either. And that's why I think the health care piece is very important, which I know you alluded to, Mr. McCosker, and which we're dealing with as well. But there's a million ways we can pick this apart. We can say, why should people go to 90% of final compensation? Well, it does make it much more difficult, and it slides so that it's less generous on the way to that, and somebody really has to put in the full time to do that. But even if we don't get support, I hope that we can get a lack of opposition to this, and that we can at least put this before the voters and let them decide if this is the right way forward. And the last piece I'll say is, both for fire and police in particular in the past, I'm very sympathetic that we don't want to do something where suddenly 5 or 6 years from now the two were not competitive and we can't get the workforce that we need. That is critical to do as well. So I don't know if in here there was any discussion, because we've talked about it before, but a sort of elevator clause where we can't make it worse, but we have some flexibility if we want to temporarily ever make it better with competitiveness. Every other agency is suddenly giving more generous benefits in a better time, but we can return that elevator down to the ground level, never to a basement, but at least raise that. Is that something that we've looked at? You understand what the concept?
Mr. Miller?
Yeah. Yes, I do understand the concept. I think that that issue, I think, really goes to the salary negotiations and COLAs, because that obviously has a direct impact on the long-term pensions. I would suppose that there's no reason why we couldn't put in the charter the ability to increase but not decrease without voter approval. But again, I think you get the same place through negotiations on COLAs and salaries and other pension-based benefits, rather than actually increasing the pensions themselves, because what that has a tendency to do is, as we've seen in Lacers, is giving pension increases in lieu of salary increases and creating a huge liability, which then comes to roost 15, 20 years later, which is part of what we're dealing with now.
Well, here's the only advantage that I would see. Instead of doing a charter voted upon tier 7, 8, 9, 10 forever, is that you're able, like right now, if we were able to bring it down to, we're at tier 5 now, so tier 4, which is one of the ones we studied. I mean, tier 4 actually doesn't save us as much as this, but let's say we had that flexibility to, again, only take it down to the ground level, but then in certain years we could have taken it up to be competitive, but knowing that would be temporary. It seems to be much better than this very cumbersome process of always going to the voters, figuring out. It just doesn't let policymakers have much flexibility. We always have to go back or depend on negotiations and other parts of the contract.
Well, the problem's been with police and fire mandated by charter for a particular reason. I think if we were to modify that, there'd be a big backlash from police and fire.
Well, I think there's been an openness at the league. I mean, I've heard this from the league, and curious to know what EFLAC feels as well. But there's been an openness that look, they don't lose anything by the ability for us in a year in which we're not being competitive anymore. Instead of having to go back to the ballot and permanently reset it, to be able to say, let's try this for a couple of years, see if we get the people we need, and then we can bring it back down by our own action rather than having to go to the voters. That would have to be a mechanism in the charter change we make, though.
Mr. Parks?
Yeah. I think, just from a perspective of the community I represent, I think there'd be a poison pill if the community voted on something and knew that it could be altered upward by ordinance. I think that's the whole purpose of putting it in the charter, that they want to be able to say yes or no. And I think that would send a message to folks that it's just momentary, and we're right back into that high volume of dollars into the pension system.
So I think, way up and no way down.
Yeah. Well, you go down. Yeah. It would be
and I think if you were putting your money into a pension system, from the police perspective, at least from my experience, you would not want people to be able to lower it by ordinance. You'd want to go to the public. So, I mean, it's one of those issues. I think you lose the public by giving that freedom to go upward, and you certainly lose the members by saying I could drop it below.
Thank you. Okay, Mr. Kretz, you have any other comments before we take a vote on this matter?
I guess my only thing would be to continue to encourage the meet and confer. I think that's critical before we get to November 3rd.
That's a question for the city attorney. Is there a meet and confer?
I think what I'm talking about is let's just offer the dignity and respect to just meet and consult, meet and confer, meet and discuss, meet and greet. I think, in fact, when I sit here and listen to this whole conversation, I don't know why we didn't, really have these conversations for this whole year, because we've been talking about this for a long time, and I think the resistance to meeting with both these entities is unfortunate. I mean, we should have been doing this since January, and we would have by now, I think, had an agreement.
We are running out of time, so I'd ask a specific question to the city attorney. Meet and discuss is one issue. Meet and confer is a different issue, a technical issue. And we don't want to have, at least I don't want to have the police and fire opposing what we're trying to do for pension reform. Is there a legal obligation requirement that we do a meet and confer?
Well, Jennifer Hanslick had to leave, but I know that their position from the labor division of our office is that there's no meet and confer requirement, that you have meet and consult, and that is sufficient.
Okay, but there's a whole different process of meet and confer if it breaks down, where you go to impasse, et cetera. And I want to make sure that if we pursue this, and it sounds like there's approval or tacit approval from the bargaining units, that it doesn't backlash. And if it would require additional time to discuss, but as been stated, we're running out of time if we want to put this on the ballot. Mr. Parks?
I think we just clarified that in council the other day with a report that the wording said it was premature, and actually the city attorney came up, or one of his representatives, and said that the language was not necessarily accurate, is that we do not have an obligation. And I think it's not just a matter of what you said is an issue here today. You're talking about a precedent that you will overwhelm the system as it relates to things that you have no obligation now become a part of that obligation. And I think that's what the city attorney has advised us, to protect our management rights as to what you can do without meeting and conferring, and what you can do meeting and consulting. And so the whole system is based on that prior advice and their continual advice, because I think clearly, as we've talked about this, is that it's been, in my 45-plus years in the city attorney said the same thing, that unknown employees or future employees are not represented by anyone. They're only represented upon becoming an employee. And if you give that up, you're creating a dynamic in the whole process that I don't think you would want to then break down the decades and decades of precedent.
Right. The employees that have not yet been hired are not represented by by the labor unions for the current employees, so therefore there is no meet and confer requirement.
That's right.
But I do want to add, I mean, directly to Ms. Hahn's point, I don't want anybody listening to this to take away from this that there isn't a responsibility to sit down and talk, and there shouldn't be that dialogue. That is not the case. What we're talking about here is a legal labor law distinction, where a meet and confer process requires certain meetings. It requires declaring last, best, and final. It requires declaring impasse, going to the ERB. It's a very specific legal process you have to go through. So there has to be dialogue. There must be dialogue. I don't want anybody to think that there isn't dialogue in this process.
And there has been dialogue according to the representatives from police and fire.
That's right.
So, Mr. Parks, you have a motion?
Yes, I would move that we would, let me get my right book here, that we would, first of all, I think we've covered item 1 and 2, that it's going back to a joint meeting of personnel and budget and finance. On item 3, that recommend that we would approve the CAO's recommendation as to the Tier 6 for the police and fire pensions that would go on the ballot. That we'd also ask that the CAO prepare for the ballot the language to transfer the sponsorship authority from the board, DWP Board of Water and Power Commissioners to the council for their pension plan. And so that would be my recommendation, that we adopt the recommendations of the CAO report October 15, 2010.
Mr. Koretz?
Mr. Parks, could you clarify the DWP part, exactly what that would be?
On page
that
4,
would entail?
Yeah, on page 4, paragraph 2, it talks about the charter section 1186, and it talks about the issue of the Water and Power Board has the authority to deal with the makeup of the plan amendments, but it also says that the charter needs to be amended, would transfer the current plan sponsorship authority from the DWP Board of Commissioners to the City Council, would then allow the council to have jurisdiction over that pension fund and plan, and then they could then create a new plan, as we're doing with both Lacers and police fire.
Yeah, I'm not sure that having both of those on the same ballot would necessarily be a great idea, so I don't know if you can break apart that motion. I'm not sure I'd side with you on the DWP piece.
We can separate it, but the issue is from all of the time we've been discussing this in EERC and other places, the plan or the view was to do pension reform as a package, because leaving any one of these out, particularly when there has been so much discussion about the DWP pension being significantly more generous than any other plan. And so we can break it out for vote, but clearly the plan has always been that all of these be dealt with in a similar time frame.
Now, are we talking about this being...
Mr. Koretz, let me find out if the mayor's office is present who could comment on the water and power. Anyone here from the mayor's office? No one here from the mayor's office? I thought we could resolve that matter, but they're not here. Okay, Mr. Koretz, your
Chair,
comment.
They'd have something to say.
The item the piece of it that I'm not totally clear on additionally is, are we talking about this being the same measure that includes DWP and sworn, or
No, it would be a separate
approving
measure.
two separate measures
separate
at the same
yeah.
time?
It'd be a separate measure on the ballot. They wouldn't be together.
Yeah, it'd be two charter reform as separate issues.
So, Mr. Parks, you're asking for them to come back with something regarding pension reform.
Well, it has to be drafted.
Draft something, right?
Yeah, we have to have it drafted so we can consider it.
Yeah.
Otherwise, you miss 2 years of bringing this before.
And they haven't done any work on it, which is going to be difficult to do anything if they haven't started the
Oh, no,
process.
so we're not asking DWB Board to do anything. We're not asking them to change the plan. We're asking that the ballot measure gives the sponsorship to the council, and then the council will have the authority to then deal with the plan.
Okay. Yeah, I'd want to look at those details too, but I don't think drafting it, there's any problem with.
Do you understand, Mr. Miller, where we're going with
Come
that?
back.
Yes, I do.
The draft aspect?
It's actually, it's a relatively simple charter change. The discussion behind it is not, but the charter change itself is relatively simple.
Right. Okay, Mr.
Could we
Kretz?
simplify that conversation somehow?
Does that satisfy you, Mr. Kretz?
I think if what we're approving right now is drafting, I'm willing to let that go forward. I'm not necessarily committing to support it at this point.
No, it's not asking for that at this time, just that the draft be done.
Yep.
So, Mr. Parks, the motion, seconded by Mr. Kretz. My other colleagues support it?
Rules and elections.
Mr. Garcetti?
With that caveat?
Yeah.
Okay, and that's approved unanimous by both committees. The next item is number 4. And there's a number of items that are being requested, 9 actual items.
The reality is that somebody.
Communication
Or-
Personnel Department relative to
Yeah.
updating employment provisions of the charter. And some of these are rather simple, and others are somewhat complicated. So why don't you begin, please?
Raylan Napper, Personnel Department.
Janice Wood, Personnel Department.
First, I'd like to state that since submitting this report, we've had an opportunity to discuss the proposals with a larger circle of people, and we'd like to withhold 3 proposals, and what has been just distributed is a list of what we intend to go forward with, and the 3 that have been deleted.
So you want to delete,
From the original report, it was number 3, 4, and 6.
3, 4, and 6 to be deleted, I should say.
Deleted, yes.
3, 4,
The
and 6.
expansion of non-general funded exemptions. The leave of absence from civil service. This was to prevent the one-day appointees.
Correct.
And then like qualified promotional, okay.
And which was the last one, I'm sorry?
Number 6.
Exempt employees to qualify per exam, promotional.
Those are going to be deleted?
So we'd like to have
They
further
want to-
discussion on these matters before we meet and confer and go forward.
So why don't we go by the ones that you're asking for?
Okay,
Start with number 1.
that sounds great. The mayor's authority to transfer. This is a power already in the charter, and we're recommending that it be extended from 120 days to a year. And this will provide more flexibility to cover gaps in staffing or to work on special
Fine.
projects. For example, it's been used in the Office of Finance to collect business tax. It's also been used by lacers to process early retirement.
So this, the city employee is going to be reassigned to the department without the employee's consent from 120 to 365 days.
In the interest of time, I know it's in the ERC, we saw them, I know Mr. Kretz and Ms. Hahn are here. Do you want to pull out whichever ones
Right,
are?
I'd like to talk about 10.
Why don't we
because-
pull out the ones that we have any
Because I
questions
think
about?
10,
and
the
if
fire
not, we can-
department actually has an issue with.
Yeah, numbers.
Okay, hold on, before we do that, if
Right.
we can just, which ones we're going to
So
pull out?
one, does anybody have any issues with?
No.
Not, okay,
Okay,
one.
one's okay, Mr. Parks, one's okay?
Two, we
2,
are.
okay.
2 is okay?
I just have one question on 2.
Mr.
go
Parks, 2?
On 2, does that authority limit that selection internally, or does it give additional authority to go outside of the department?
They can go outside the department. The process would be governed by Executive Directive 6, which governs the selection of assistant general managers.
I mean, does that broaden the,
Yes, it'll broaden the pool.
so this is be the first time that they'd have that authority?
Correct.
They couldn't just do exempt with their own pool?
Correct. Actually, I believe they had 2 automatics.
Okay, I think we need the fire chief to weigh in on that.
We have representatives from the fire department to discuss their 2 items.
We can
number
pull
2
this out if we wish. Let's pull this out.
I just want to make sure that they're clear if they're proving the flexibility, that it's flexibility far greater than just exempt inside. If they're approving exempt inside and outside, then they need to clearly understand that before it goes on the charter.
Okay.
Okay.
Expanding automatic exemption, so it should include a wider base.
Right, yeah.
Sir, do you have a comment, brief?
Yes, sir. Brian Cummings from Planning Section Battalion Chief, and yes, the fire chief understands that the exemption is for inside or outside.
Okay. Fine. So with concurrence? Yep. Support number 2, 3 is excluded, 4, so let's go to 5.
Okay, number 5 is just standardizing the length of probation for all sworn police officers. You know, we have police officers in a number of departments, and currently, so 3 of those departments, their probationary provision is under the civilian provision. So we just like to group them all together for consistency.
Wait, is that number 8 or number 5?
Number 5.
We're
We're number 5.
Examination.
Yeah, we're going on the new list.
Oh, we're going on the old one.
I'm on
Right?
All right, hold on.
Oh,
Then
you're on the-
then
I thought
maybe
you
we
were
were
on
getting rid of the wrong ones.
Okay,
Right,
which
we're
one are we
going-
working from?
No, I'm on the
We're
new
working
list.
through a matrix that was provided to us by the CLA, I believe.
have the right
Right?
one, right?
That's what this one is?
The new
What happened to 2, 3, and 4?
No, I have. I was.
Oh, this is from personnel.
Right, 5 is, I got,
It has one is mayor's authority transfer, 2 is expansion of automatic exemptions, 3 was expansion of non-general funded exemptions, 4 was leave of absence from civil service,
Right.
5 was efficient administration of examinations.
Right.
Okay, okay.
that's
The old
totally
list. All right.
different.
So number 5,
Is there another list that you have that we haven't?
Wait,
had
wait,
the
to
one
do?
that was handed out, I believe.
Wait, say that there's a whole new list. Let's.
Oh, you
start
just handed this
over.
out on our.
We have 3 different lists, and none of them have the
Match
same
up.
information.
Right.
that's not
So
okay.
there's a list that says proposed revisions, and it has mayor's authority to transfer.
Oh.
Section 233, that's the
okay.
first one. And then it's got section 1001, Mr. Garcetti, that's not the one you've got.
Oh, so you
No.
Maybe we could use the longer list with
Let's just-
11
let's
items.
just
It
stay
has
on the old
11
one.
items.
Let's stay on the old
Let's
one.
just stay on the old.
Okay, stay on the old one. All
Let's stay on
right.
this old one.
Yeah, if we need, if this is the one, I don't have that.
Yeah, that's the one.
Stay on the old one.
Which
Okay.
one is the old one?
The long one.
It has
everything.
11 items.
Okay.
I
Right.
don't have the old one in here.
11, and we're taking out
Oh,
3,
you gotta
4,
read it.
and 6.
3,
Talk
4,
about
6.
later.
Yes.
Right.
It's
No,
attached to
wait,
that.
wait. I don't have the old one. I have the newer one.
Okay.
It's attached to that.
So we're
Why
going to
doesn't he
get
have
the old one.
one? Why don't you
Okay,
have the
I'm
old
with
one?
you.
All right.
Should have been in your report.
Okay,
We can.
let's go through them one at a time, folks. Okay, so,
Start with number 1 again, to make sure we're on the same.
No, wait, the one never changed, old and new.
one was the mayor's authority transfer.
We got
Okay, we all agree on that.
Right.
Right.
Well,
Number
it
2,
depends, because there's 2 different sheets they handed out, so there's a 1 on this and there's a 1 on that.
Okay.
How about if we just read out the...
I'm going to
subject-
share with Mr. Zine, otherwise Ms. Hahn and Mr. Parks do have the old one, so we will go by the quote-unquote old one. There you go.
Isn't the mayor's the same?
So we did mayor's authority to transfer.
And then
Done.
number-
Expansion of automatic exemptions. Fire
No,
chief,
the
done.
one's the
that's
same.
okay.
3 and 4, we're skipping for now. 5, let's call that the efficient administration of examinations.
Okay.
Approve that one?
Yep, I have
Okay, that
no
one's
issues,
okay.
everybody
Are there
okay?
any questions or issues?
No.
No,
Okay.
we discussed that in the EIC.
Number 6,
Skip 6 for a
Skip
second,
6.
the higher level jobs one, right? That was one of the ones you
Right.
were recommending, that, we'll come back and see if people do want to,
well, they're deleting 6, I understand.
well, they're recommending it, it's up to us,
Okay.
the committees do that.
We're holding 3, 4, and 6 now.
We'll come back to 3, 4, and 6 and see if people have issues. Number 7 is the elimination of unnecessary steps in the certification process. Anybody have issues?
No.
Okay, that looks good. 8, clarification and standardization of the length of probation for police officers, that's what you talked about before.
Yeah.
Any questions, issues?
That's right.
Do we, on this one, we have port police, airport police here to at least comment on whether they're okay with that?
We've spoken to their unions.
You
They're
meet-
okay with
Did
that.
you meet and confer, you just,
We have not met and conferred, but we will. They are invited.
The only thing about that is because on 10, I know, I've heard that the UFLAG had some issues with that, so I would be concerned on 8 on whether or not, I mean, I'd like to hear from them
Standardized
before we put that on as a ballot change. I know you have, but
length of probation.
I want to hear from
Do you want-
port police, airport
Do you want to do
police.
this? We can add it to the list and say, by the time in council, we'd like to report back to make sure that's
Right.
confirmed with those units as well.
Sounds
Okay,
good.
let's do that. Okay, 9, extension of emergency appointments. Anybody?
No problem.
Okay. 10,
Yes.
disciplinary procedure.
I
Could
think
we-
UFLAC has an issue with this.
We might want to jump to 11 first
Okay,
and
yeah,
then
so
go back
that's
to the fire
non-controversial.
department.
Good idea.
Employing retirees, extending the amount of time retirees may work from 90 to 120 days.
That's okay.
No problem, okay. So that leaves us with, on the old list, 3, 4, 6, and 10. Let's go backwards. 10.
All right.
So you want to give us the arguments?
I'll let the fire department
Okay.
speak.
We have comments. Pat McCosker and Cheryl Parisi both fill out cards on number 4, on item number 4.
Is somebody here representing the fire chief?
Hello again.
Is someone here representing the fire chiefs? Fire chief? Okay. Mr. McCosker, go ahead, Pat.
Public comment first?
Yes.
Okay, thank you very much. Pat McCosker, President, United Firefighters. This baby is meet and confer. This affects, current employees. This affects our work rules, the disciplinary system. And it may seem benign to you, by the way. It sounds good, like we're going to get this old city charter, this creaky old charter of ours, in line with this new state law, the California
Excuse me, I
Firefighter.
take offense to the creaky old charter. We haven't had a brand-new charter in 1999.
Amelia
That's
Earhart was one of the charter commissioners.
barely 10 years ago. Okay, go ahead.
But newer anyway, Bill of Rights. Point well taken. But, I actually know quite a bit about the Firefighter Bill of Rights. I'm the father of the California Firefighter Bill of Rights. It was my idea. I'm on our state board, and I made it our top legislative priority, and we got that done just a few years ago. It was a landmark legislation that created new protections, new laws for a lot of firefighters in the state that didn't have adequate protection. But when we created that law, what we lobbied for, and the intent of that law is to not strip away, not lower protections for any firefighters that already had them in categories, in areas. And we have certain protections here. I know the one that's talked about, if you don't mind me going beyond a minute here.
Go ahead.
The one that's especially been talked about, and probably what's behind the fire department's effort to change the charter right now, is the provisions regarding tolling and the statute of limitations. We already have rules here, and they slightly exceed what the Firefighter Bill of Rights provides to other firefighters in the state. So what would really be happening here is we'd be taking away rights from your firefighters. And that is something that is not necessary, not wanted, and is the subject of meet and confer. We were only asked yesterday to meet and confer on something regarding charter change and discipline, and we only have a meeting scheduled with them on Tuesday, and yet it's here before you. I would urge you not to move forward on this. Give us an opportunity to meet and confer, and I hope work with us to make sure that your firefighters' rights are protected, not stripped away by our own law. We don't want to be beaten over the head with the law that we went out and fought for so that firefighters around the state could start gaining some rights.
All right, thank you. Can we hear from the fire department on this? Sure. Well, you'll come next. You'll come next. Go ahead, sir.
Oh, he didn't know you were up.
Again, Brian Cummings from the fire department. The intent of the charter changes that were put forward were in response to, as Pat said, to bring the city charter in line with AB 220, which is the Firefighter Bill of Rights, so that there weren't the conflicts that the recent report by the independent assessor pointed out, the fact that a lot of times there were conflicts that came up between what's written in the charter and what was written in AB 220, and instead of having to go back and forth and find where the conflict is and which one applied when, we're seeking to bring the charter language into compliance with AB 220 as we
Which
move
is more
forward with this.
restrictive, the state law or the charter? Because the state law would normally supersede.
But what was happening in application was that whichever one was advantageous was the one that was used. So to apply consistency, we want to bring them in line, bring the charter in line with that.
Other than the statute, is there anything else other than the statute of limitations?
There are several items in there, believe at least a dozen different items that it talked about, nomenclature about naming calendar days instead of shifts. It talks about...
So it's a lengthy discussion regarding a number of items.
Correct.
So this matter, I'm not ready to support something
No, me
that
neither.
still hasn't had a meet and confer. I'd prefer that we pull this particular item.
I agree.
Mr. Parks?
Yeah, I don't think it's ready.
Mr. Barnes doesn't think it's ready either. So we're gonna pull 10 and send that back for meet and confer process, and may not make it to the charter.
Right.
But we're not ready to proceed with that at this time. And we'll hear from Cheryl Parisi
What we do have, by the way, is another meeting next week on things for the ballot. If there's progress that's made, I mean, I think there's openness, but I don't even know what tolling, excuse my ignorance, tolling and statute limitations refer to, so I would also not be in the position yet of, we'll sign off, but we do have a week, so if folks are sitting down talking next Wednesday, we could bring it back. We can continue it at least for rules and elections for now to keep it here. Okay.
Thank you. Cheryl Parisi, stand-in?
I am not Cheryl Parisi.
No, I said her stand-in.
No, I know. I am
stand-in.
Jason Elias from SEIU Local 721, and I am standing in for Julie Butcher, who is going to stand in for Cheryl Parisi.
Oh, okay.
You're the stand-in.
You're third in
and I should stand up straight if I'm going to stand for Cheryl. So, as you know, representing the coalition of LA City unions, 22,000 members, civilian employees, I do not have, now, we're happy that a couple of the most contentious recommendations have been taken off the table for the time being. I do not have to remind Councilmember Hahn, and I will not call you creaky, nor will I call the old charter creaky, the new charter creaky.
Really?
After 22 months of arduous discussions, the elected Charter Reform Commission, the appointed Charter Reform Commission, before it came in front of the City Council, we met and conferred over the proposed charter. So, along the lines of my union brother, we actually, although the recommendation here is to approve in concept these recommendations, we would actually like the city to meet and confer with us before they are submitted to you folks. We're happy to continue that process. I know we've had some discussions, but we just think that is a necessary precursor before the council actually makes motions.
Are you speaking about all of these recommendations or specific ones?
No, I mean, we're speaking, we certainly have concerns about specific items. I'm not prepared to speak about that today, but we do have concerns about a few of these items, and we do believe that the meet and confer needs to come before recommendation and putting these on the ballot.
Well, there's a total of 11 items they're proposing, and they're pulling 3, now we pulled 4 of the 11. And if there's, like, extending the amount of time retirees may work from 90 to 120 days, if there's any specific items, then we'd be happy to consider pulling those also. But some of these are really not controversial.
Right. No, and certainly, I mean, if we had the time here, I mean, I don't really feel it appropriate for us to negotiate here in open session, but certainly we could have had a discussion beforehand.
Would you represent for item number 8, on the right page here.
Got the old one or the new one?
On the police officers, the probation, would you be representing those individuals?
No.
No, I mean, we don't have a dog in that fight.
Okay, well, the ones that you would have jurisdiction over.
Right.
No, sworn officers.
But I mean, I think you make a good point, because I mean, we're willing to approve some of these we don't have problems with. When I was even thinking to eliminate the need to test all qualified applicants, maybe, the workers have an issue with that. Allowing exempt employees to qualify for promotional exams. You're right. I mean, there might be some of these that needed to have some more dialogue.
Was the union, was Cheryl Parisi or Julie Butcher ever consulted any of these items?
I did have informal discussions with Bob Schoonover, Julie Butcher, Cheryl Parisi, and other union representatives, including IBEW and so on. We have also sent a letter inviting all of the unions to meet and confer with us on 12 separate occasions throughout, from the end of this week throughout next week, and we have further offered to meet with them on 4 different evenings if none of the
on these items
are convenient to them. And I think also importantly, these are conceptual items, and we want to meet and confer with them before the specific wording is finalized, and that is what would come ultimately before you, and that would come after the meet and confer process.
Then why wasn't that done before it came to this committee? That should have been
because
done
we
before it
have
came
to
to
get
committee.
bargaining instructions from EERC before we can
We did.
negotiate with the
We met on
unions.
Tuesday.
Do you actually feel like this process will be...
instructions on Tuesday.
Do you think this process will really be completed before our time? And is there an urgency to put these items on the March ballot?
I think there is an urgency in that there are other proposed charter changes going forward relative to pensions, and so I think it makes a lot more sense to the
But
voters
they
to
could go
look
on
at
the
these
May ballot,
together.
for instance.
If there is one.
If
That's
there
not a
is one.
citywide, we don't.
Oh,
Well,
that's
it's
right.
most likely that there will be. I mean, this is prognostication, but I think it all takes is one runoff in the community college district, which there probably will be, and then that covers the entire city since those are at-large seats.
I'm not sure I see the urgency, really, of any of these.
Well, one of the problems I have is that this is being brought up at the last minute. We want to rush. So it's not really fair to the public, the employees, us on a committee at 5:45 in the evening, because it's been rushed through. It needs to be vented appropriate manner in a timely process. And it's kind of like we're last minute rush, get this done. I don't really like to do charter changes in that manner. I would suggest,
Right.
Mr. Chair of the other committee, is that we push this to another
Always
date
wanted that title.
and do it in a proper fashion. Instead of
Well,
rush.
I agree, and I think these might be very reasonable charter changes, but as Mr. Corrett says, I don't think we want to go into an election with any of our employee groups opposing these. I mean, I think that, again, would be a waste of our time. And until they, I think, have sort of signed off on these, it doesn't really make sense for us to put them on the ballot.
Just to clarify, right now, we're not asking you to put them on the ballot. We're asking you to approve in concept so we can meet and confer, report back to full council, and at that time, you can decide what goes on and what doesn't. We can report back how labor feels about each one.
But didn't you already got those instructions from ERC.
Hold on, Mr. Parks.
No, I think it would be helpful, because you did get some direction from ERC, is that if we, in concept, sent the list back to them and said, come back on the 27th as the next cut and see what progress they've made, and then we have on November 3rd, and even after November 3rd, I believe you have,
What's the urgency?
not November 3rd,
Yeah, and if we don't hit that, then we'll
we
look
still
at
got
then
2
we'll look at
weeks
May.
after
I don't
the
see
due
these
date.
being urgent.
But when EER sent it out to meet and confer and discuss.
Yeah.
Not here.
We covered it. ERC has given those instructions. Why don't we hold it, and we'll see if there's progress on some or any of these for next,
Right.
and we decide to do it for next week, we can do it, and if not, we'll hope that there's a May ballot, and look at it for then.
We're going to hold that.
But you don't need any further instructions. ERC has already instructed
This
on
committee,
all
yeah,
of
this
this.
committee doesn't give them.
Item number 4 is going to be held. All of item number 4.
We come back on the 20th,
Okay,
27th.
good.
27th, we can look at for next week.
Any other comments,
Item
colleagues?
4 of the new list or the old list will be held.
No, the whole item.
No, the whole item. Me and confer about all these, confirm, the ones you might have had suspicion about. If there's a couple that don't require meet and confer, we'd be happy to hear that too from the CAO.
Yeah, I
But if they all do, let's just do
I
it.
don't think you're creaky.
Okay?
Thanks, Bernard.
All right.
Any other comments?
Thanks,
Sure want
guys.
to speak.
Thank you for this committee.
Thanks for your patience too. The personnel folks are dismissed, excused, and
You
thank
still
you.
here?
Well, we still have 3 other ones.
Good luck.
So we're through?
We're done.
Oh, man, how come they get to go?
Now we have items 5, 6, 7, which I think we're going to take to get. We've heard
I'm gonna leave with creaky over here.
Creaky is dismissed.
I know. Pat McCosker, you will never live that line down.
All right, if we can take up 5, 6, and 7 since they're related, let's take them together.
What you want me to read?
And I'd like to take our public comment first on this. Unless do folks want to wait and hear before they give public comment, or folks want to give does anybody need to go and want to give public comment first? I'm happy to accommodate. Show of hands. Okay. All right. We'll hear then from the city staff first, and then we'll make sure everybody gets time to comment. All right. So we have before us 3 different reports, or more than 3. We've got a clerk and a CLA report on vote by mail, clerk and CLA reports on RCV, the artist formerly known as IRV, and then we have a CLA report on number 7 as well. So why don't we hear from the CLA first, and then we will dig in from there.
Certainly. Charles Modic with the CLA's office. You summarized the reports that are before you accurately. I should note the CLA report. There is one CLA report that responds to items 5, 6, and 7.
Okay.
There are 3 issues before you on these items. All of them relate to reform of the city's election system. One is whether or not the city should pursue moving forward with vote-by-mail only elections, where there would be voting by mail with neighborhood voting centers. The next issue is whether or not the city should move forward with instant runoff voting or ranked choice voting. And the final issue is whether the city's matching funds program trust fund, if the cap on that should be removed to allow an unlimited amount of money to accrue in that fund. Our report addresses all 3, as I said, and I'll go ahead and take those one issue at a time. The first issue that we'd like to address is vote-by-mail elections. The city, now this is a policy decision for the council to make whether or not you want to move forward with changing how elections are run. The city clerk has provided a report that addresses how you could go about having vote-by-mail elections with neighborhood voting centers. That report notes that you could have ballots that are mailed out to all city residents in a single district to be returned either by mail or dropped off at a polling place, and that depending on the number of polling places that exist in a single district election, this may be cost neutral or actually result in cost savings. The actual cost for these would depend, of course, on how many polling places were open. The next issue before you is whether or not to remove the cap on the matching fund program trust fund. Right now, that program the city charter requires the city to make transfers to that trust fund of $2 million a year up until that trust fund has a $8 million balance. Both of those amounts are to be adjusted annually by the Consumer Price Index, and since that charter amendment was put in place, the amounts to be appropriated per year have increased to $3 million, and the cap has increased to about $12 million. Whether or not the cap is taken off is, again, a policy decision to be made by this committee and the city council, but we would like to note that if the city council does decide to move forward with eliminating the cap on the matching funds program trust fund, you could be opening up obligations to continuing to make that transfer of up to $3 million a year. Right now, we are at the cap in that fund. And we would like to add that if you do decide to go in that direction, that you may also consider creating a provision that would allow the city to balance against, or to borrow against the balance in that fund, so that there's not just a large pot of money sitting there unusable. Finally, there's the ranked choice voting system. As was addressed by the city clerk at your last meeting and the City Ethics Commission as well. There's a proposal out to change from the current system that calls for a majority to elect a candidate for office, and if there's no majority, to move on to a runoff. This would change to ranking your choices to your first choice for your candidate, second choice, third choice. It would change the system there. In order to do this, the city clerk reports that there would need to be a significant investment in a new voting system. The voting system is estimated to cost around $40 million or so. I believe the county is currently working on putting together a new voting system that we could have access to, but the city clerk will be able to provide you with more details on those.
So just let's take up that issue real quick. I mean, we're going to be buying or using new voter equipment in the future, one way or the other, whether we have ranked choice voting or not. Is that accurate or not?
Holly Walcott, Executive Officer, Office of the City Clerk. It is true that both the cities and the county's voting systems are antiquated and they need to be replaced. The $40 million estimate came from when we did an RFP last year. That is a ballpark figure because clearly we didn't pick any of the voting systems that were presented to us. We do need to work with the county to purchase a new voting system, whether or not ranked choice voting is adopted or to go to the ballot or not. We still need a new voting system. $40 million again came from our RFP process. I also wanted to clarify that we do anticipate significant costs for that new system, and that the 1 or 2% part of the ranked choice voting that we anticipate, again, is just a ballpark, and that would be split
I'm
by...
sorry, what are you referring to, the 1 or 2%?
We anticipate...
1 or 2% additional cost, or?
No, 1 or 2% of the total cost of the system is likely to be the ranked choice voting component.
Got it.
So if it's a $40 million system and only the city is using it, that would be on us.
Gotcha.
So hopefully that clarifies
Yep, thank
the
you.
discrepancy between.
Are we planning on getting a new system anyway?
We are working on it. We went out to RFP last year. Currently, the county has just completed their voting assessment project. They have milestones that they have published, although they don't really have a clear timeline in their new report. They are looking to build a new system as opposed to buy off the shelf. That's at least what we hear right now. Their goal is 2014, but I'm skeptical on whether they can actually meet that deadline.
And when are we proposing this?
Well, as Mr. Huizar stated, this is for a policy direction.
But when are we proposing this ranked choice voting election?
We would be proposing it as a policy decision and for the trigger to be when it's feasible. Because we could not, we would not.
Okay, we're not proposing this for a specific election right now.
We would be very opposed to that because there's not even specifications right now of the new voting system. So if it is the council's policy, you should direct us to work with the county on the purchase of a new system or the build of a new system. And if it's your policy decision to include a ranked choice component, we should make that
That
request
should be part of
to
your
the-
RFP.
Well, we need to make that request to the county now. So either you should direct the city clerk to formally correspond to the county, or the council can adopt a resolution.
Okay. So part of what I think has been, and which we have some speakers who can articulate it too, is whether or not we allow for the mechanism of ranked choice voting in anticipation of, and in some ways to hope to drive the purchase of technology that would allow for ranked choice voting. Folks, opposed that have said, why don't you wait until you have the stuff in place, and then we can talk about whether we adopt that for the charter or not. So I think those are the two sides. I've voted for and still would support moving forward with us being able to, with eyes wide open, knowing that it's going to be a long time probably before we can do that. The vote by mail elections piece, which looks at being able to, for one of the special elections, do that, I think is straightforward. I hope doesn't face any opposition, something I'm very supportive of, and it wouldn't have any negative impact on the city's general fund.
Well, wait, I thought the report said that if the projections of vote by mail actually came true, like a 700% increase, that we would need to hire an extra, like, 560 employees. That's what I'm reading from this report. So that
This is the
sort of be
October
a-
18th report, or?
The city clerk's election division, based on a 700% increase in workload to conduct an all VBM election, VBM staffing would necessarily
Oh,
need
if it was
to
all VBM, yeah. This
increase.
was,
The city clerk could not do an all city. This is
that was a
talking about.
citywide one, right?
Yeah.
Not
Okay.
an individual district, yeah.
Panic.
Okay.
We could not do a citywide.
Got a little
right now.
scared there, huh?
Okay, so what are we proposing here?
So it'd just be for special elections.
Well, it's a policy decision. We would recommend for a single district, although I believe what Councilman Huizar would like is for it to be open and for the city clerk to be the trigger mechanism that if we recommended a future date, that we do have the capability to do an all vote by mail, that we do it at that time. But right now, what we're presenting is that we are in favor of a vote by mail in a single district. And if it's your policy to leave it open for future, then we would recommend two things: that the trigger be the city clerk's recommendation on feasibility, and for both ranked choice voting and for vote by mail with neighborhood voting centers, that there be an out clause.
Would there be a what clause?
An
out clause.
In other words?
We could return to the traditional methods.
Right. Sure. I think that's reasonable.
And in vote by mail in a single district, how many what are we calling them? Neighborhood
voting centers.
How many would there be?
Utilizing the CD2 special election that had a $1.8 million budget, there would be 67 to break even. What our proposal is in our October 18th report is for that to be decided at a later date. Each council district is different, and we would need further analysis and we would be ready when a single district vacancy was held. We would bring that recommendation forward. I don't know if the city attorney has further trigger points that they would need clarified.
Harith Trivedi from the City Attorney's Office. As Holly mentioned, I think we do need some direction as to the triggers and the standards in the charter language that we prepare for the vote by mail measure. What's been discussed here is the clerk's proposal for the trigger to be that if the clerk determines that and makes findings that a vote by mail election can be conducted when a specific vacancy arises, then they would make that recommendation to council, and then when council adopts the ordinance calling that election, council would have a decision there as to whether it would be an all vote by mail election or a traditional election.
What would the criteria be for the trigger?
It would be administrative feasibility, cost, taking into account the analysis of the district itself that was vacant.
And also in line of what the out clause idea, if the election could be consolidated onto an existing election, a state or county election, that would be one reason why you might not want to do a vote by mail election, because they would not be able to handle it for us. So those are the types of factors, and we anticipate building some of those into the charter language, consistent with your direction. So that's provided in the charter with further administrative components developed in the election code to be developed later. The other element is the neighborhood voting centers, and you'd asked how many there would be, and I think the clerk's recommendation is that it be determined by the clerk based on the particular circumstances of that district and the district's needs and the communities in that district, and costs and administrative feasibility, et cetera. And we try to develop some language to include those criteria in the charter with the actual determination made on an election-by-election basis by the city clerk if and when a vacancy arises. That's how we anticipate it, and we'd appreciate any direction from the committee on those issues.
Okay.
Right. Again, I have given my commitment that I would at least get to vote to get this out of committee and to the full city council. I know personally I have a lot of issues with this. I just think there's such a tradition among so many in our society that really like voting at the polling place. I know in the African American community, it's kind of historically, it's a matter of trust, and it's a matter of, really believing that they want to walk in there, they want to vote, they want to talk to the ladies who are working the polling place. I mean, it's kind of a tradition. So, I'm all for, moving us forward and being progressive, but I just know for a lot of people, they take voting in person very seriously. It's part of their patriotic duty, and no matter what, they want to vote in person. So I think to take that away from people is, I think we're treading on, kind of sacred ground here. And I think to diminish the amount of, even to change the name from a polling place to a neighborhood voting center, I think you're really going to ruffle a lot of people's feathers. And these are the people that vote. These are the people that vote. These are, the ones that historically actually do vote in every election. And so I'm still a little skeptical of removing the neighborhood polling place. I think there are some people that still walk to their polling place to vote. And again, this is a time-worn tradition that people take very seriously. So I have a lot of issues with us moving in this direction. But I will, I've again said I would help to get it out of this committee and to the full city council for direction. But I think there's a lot of things we haven't thought about in this.
Did we get any information on vote by mail stats from around the city, or do we have those like per council district? Is it higher in certain parts of the city and lower in other parts? I mean, we kind of rely on these impressions, and
there might be.
True. The statistics we provided in our report are citywide.
But they might not be.
It's probably what?
The statistics provided in our October 18th report are citywide.
They were, okay.
Yeah.
So we don't have breakdown by.
do not
You know,
have breakdown by
yeah.
council.
And I know we want to increase voter participation. I think that's what everybody wants to do, but I'm not convinced that people, the reason people don't vote is because they have to go to a polling place. I think people don't vote because they think their vote doesn't matter. I think they don't vote because they're tired of negative campaigning. I think they don't vote because they're tired of the political process. That's why people don't vote. So I don't know if making it more convenient is the answer. I think people are very turned off by the system, and that's why they don't vote.
Not to sound like Frank Martinez, I think people turn out for elections that they feel that they have a stake in. There's important issues or people.
The number one reason I would say would be because they care about what's
the substance
being voted on. Yeah.
And then the rest is incremental on can we make it easier, and it's almost like doing a field campaign. Like most people, if it's a close enough race, your field campaign might add 1 or 2% because you put a lot of effort into getting a lot of people out through a lot of annoying phone calls and knocks on their door. But if you're going to lose by 5 or 6 points, you're going to lose anyway, no matter how good your field operation is. I think it's similar. So wherever we can improve, I think it's been very important. Certainly, these are circular conversations we have in this committee. They're important ones. They're the core of what we do. People have said, why don't we just do these in November on the even years? There's going to be a lot of people that turn out. If we did want higher turnout for a city election, I guarantee you that if we had city council races in 2 weeks instead of in 4 months, we'll get more people voting. But they probably would have a lot less focus and a lot less differentiation on that because and it costs a lot, so it's a barrier, as Ms. Hahn was telling me before, to folks who want to buy ads right now or spend money right now. There's a lot of competition for that because I heard one gubernatorial candidate spend $140 million plus of her own money, but there's others as well, I'm sure, that are out there. Why don't we take public comments on this, and then we'll see what we can do to move this forward and give the council some options for a full vote. So you guys can sit tight just for a second, or feel free to stretch your legs. David Holtzman is our first speaker, and for all the good government types that are still here, thank you for your patience. It's only been 3 hours and 5 minutes, but we know how committed you are to the cause if you're still here.
I split my comments into comments on number 6 and number 7. Could I have maybe 2 minutes instead of 1 minute each for these comments?
Yeah, go ahead. Don't worry. We'll be less strict on the time. Go ahead.
Appreciate it. Thank you. David Holtzman. Hello, everybody. President of the League of Women Voters of Los Angeles, and the LWVs of LA and LA County advocate using ranked choice voting to have instant runoffs in all single winner elections. And we're part of a coalition of good government groups, like you mentioned, advocating RCV and other election improvements. We expect LA County to follow through with its plan to acquire ranked choice voting equipment by 2015. And I see no reason for the city to make a parallel and duplicative expenditure. So, like Councilman Huizar suggested earlier, don't be scared by the $40 million figure you see in the city clerk's report, or in reports derived from that report. The report, by the way, is in significant ways inaccurate, incomplete, outdated, and inadequate. The clerk's office has had ample opportunity to prepare an adequate report, but, they could have done much better. In part, that's because the clerk has no authority over the city administrative officer, but assigned the fiscal savings section of the report to the CAO, and it never got done. So the worst policy decision the council members could make now would be to ask the city clerk's office to prepare another report. Instant runoffs.
I think we'll all agree then, because city clerk probably doesn't want to do one. If you don't want one, we don't want one, then we're all agreed.
I think so too. All right. Instant runoffs really would affect that office's funding, trim their mandate, and it sure does look like they've been stalling on the issue. The new equipment that the county is getting will not just enable ranked choice voting, it will enable consolidating city and county, state, federal elections. And the city of Long Beach, the second largest city in the county, is looking forward to that consolidation. And the ability to consolidate might call into question the first largest city's continuing expense of having a complete elections office separate from the counties. The city clerk has extolled a philosophy of having the city's voters' experience be as much like the experience as in county-run elections as possible. Well, ultimately, that's a self-defeating philosophy. Sometimes, and I think here, you need to innovate. But in response to the clerk's concerns, I will recommend to the coalition and to you that the RCV charter amendment not require RCV before 2017, 2 years after the new equipment is to be available. Before that, however, the city can and should conduct special elections for 1, 2, or 3 individual seats using RCV. If that means simply using paper ballots, so be it. With the low turnout we have in such elections, hand counting all the ballots would be easy. Now, if you insist on using machines, well, appropriate hardware is available. Despite what it says in the clerk's report, the Secretary of State has approved, and the cities of San Francisco and Oakland are using, on November 2nd, in a couple of weeks, RCV voting equipment. Secretary Bowen has approved those machines repeatedly and has given only indications that she will continue that practice. So machines are available. Now, please note that the clerk's report misrepresents Election Code Section 19250's requirement for federal certification of municipal election equipment. That, which they say is required, only requires to direct recording electronic voting machines. The DREs, which tabulate their votes in their mysterious interiors, do not involve paper ballots and only usually produce a paper trail behind a very small window. I don't think anybody's considering that type of machine for RCV. So machines are available. Now, if our elections continue to be off-cycle, not in November, we could actually use the machines from up north, as there are probably enough of them to cover a district or 3, and maybe even enough for a citywide vote-by-mail election with neighborhood voting centers, because we'd have fewer polling places, and they might have enough machines up north. So anyway, in closing, I want to thank this committee for moving this issue forward to the full council, and ultimately, we hope, to the voters for their decision. And on the issue of what should trigger some of these changes, with RCV in particular, the league will be providing some suggestions to Councilmember Weezer in the council file before it goes to the full council for consideration. Thank you.
Thank you. Appreciate it, David. Robin Gilbert.
Yes, hi, Robin Gilbert from the San Fernando Valley again. I've been coordinating our volunteers from the California Clean Money Campaign for 6 years there. We reach out to churches and public groups and street fairs and talk to them about clean money and fair elections. We found the voters there just really support this concept. I would like to see the cap removed from the trust fund so that we can make it a more robust system. The voters have already spoken and they approved the partial funding system. Let's give them a chance to expand this so that we can possibly have more candidates involved and give them more of a chance to run. Thank you.
Thank you. Joe Sedita.
I'm Joe Sedita. I'm chair and co-founder of California Clean Money Campaign. We started the campaign more than 12 years ago with just a discussion. Let's look at this. So I understand, I appreciate the patience of you two. This is a long time to sit and listen. But I'm very enthusiastic about all of the qualities of this. I'm proud that LA, although we lost 115 statewide, LA, we won in LA, and I'm very proud of LA, and I'm proud of you considering all these. It's a step toward a little greater democracy, and that's what we all need. I think you could be a model for the state and a model for other cities. Certainly we know that we need those models right now. So I urge you to carry forth with this plan and all the different items in it. Thank you.
Thank you very much. Is Kathy here? She had to go? Okay. Anybody else? I don't have any other cards. Come on up, Jim. You might have had multiple numbers on the previous one, so my apologies.
Trent Lang, President of the California Clean Money Campaign. So we are also very happy with these moving forward. I want to speak to both the public financing measure and the instant runoff voting briefly. On the public financing measure, we definitely encourage, and I believe Councilmember Weezer submitted these technical changes, additional changes beyond removing the cap to allow modernization of the public financing fund by ordinance later on to allow public grants to be granted to candidates, not necessarily requiring matching funds on a one-to-one basis. That's what other public financing systems these days are doing, so that would give the flexibility for that. We also approve of the idea of increasing the maximum fines for campaign finance violations from the current 3 times in the charter to 5 times, so there's a little bit more teeth to violations. So hopefully those can be added to the proposal to increase the trust fund cap. On the instant runoff voting, the ranked choice voting, we would very strongly encourage that it be put in for citywide, possibly with the condition of the clerk's approval, but we definitely want to make sure that it's not just on a special election basis, but be expanded to citywide. That, I think, is the goal there. And lastly, actually, I forget, I missed one point on the public financing portion. I think we'd be very much against any portion that would allow the city to borrow any funds from the trust fund cap. That we've seen that be very dangerous in other jurisdictions where you have future city councils that decide that they want to borrow the money and it never comes back. So we'd be very much against that sort of change. Thank you very much, and thank you for pushing this forward.
Wayne.
Thank you, Council. Wayne Williams, California Clean Money Action Fund. My support of this is because I really recognize how it gives us an opportunity to move towards voter-owned elections. What I'm concerned also about is the aspect that comes with mailing in ballots and getting voters to the polls. Councilmember Hahn, you're absolutely right that one of our real problems is people aren't showing up. And I don't know, in Australia they make you pay an extra tax if you don't vote. Maybe we could look at something like that. That might show people up. And up in Canada we have audit trails at the polling place that has to be matched by the mechanical machines to make sure that they match up. So we don't have audit trails with mail. And that really concerns me. And I personally, I don't know if I want to trust any election in this country right now. And it's a very real concern. If you check with what goes on with Bev Harris and Brad Friedman, who are doing some incredible work looking into what's going on in election fraud and elections that are taking place. We've got to pay attention to this stuff. Los Angeles has a real opportunity to do a good job because we've got some people who really care here, and I want to make sure that that happens in part of this process. So thank you for your time, and I appreciate your efforts.
Thank you. Mr. City Attorney, let me ask you a question. In terms of these items, I know that motion Mr. Weezer introduced and that I seconded had a package. Is it your recommendation that these be separated into separate? I mean, there's a tactical question which we can assess, but in terms of the legal question, are these should these be collapsed into a single, or would you recommend these be in 2 or 3 separate ballot measures?
As you may well be aware, the city is not subject to the single subject rule that applies to other types of ballot measures when it comes to charter amendments that the city puts on. So the city can bundle measures together. This was a result of a lawsuit that came out of Measure R from a few years ago, which we succeeded in and got an appellate court ruling that said so. It's a policy decision about whether to separate it out, but legally we can put things together. And these, the ranked choice voting measure and the vote by mail measure, both pertain to elections, and they would satisfy the single subject rule anyways. There's another issue, though, that I'd like to raise with regard to whether the measure should be submitted separately to city voters and LAUSD voters. As you well know, our charter covers and governs Los Angeles Unified School District elections as well. And the state constitution requires that a measure that's affecting the elections of the city and the LAUSD has to be approved by both the LAUSD electorate and the city electorate. And we recommend that.
And not the LAUSD minus the city, but the overall.
That's
and
right.
Then within. Okay.
That's right. There's an overlap between the two electorates, but all the LAUSD voters have to approve any change that would affect their elections, and all the city voters for city elections. Because this either vote by mail voting or ranked choice voting directly impacts the way LAUSD would elect their candidates, we recommend it be submitted separately to them. This is how it was done in 1997 when this was proposed. In 99, the charter reforms, LAUSD received those separately from LA City. It also avoids any confusion about a single measure being approved in part and not in the other.
Or the community college district?
The community college district is actually, it's interesting. It's not governed by our charter, but there's a state education code provision that provides that they're elected in the same way and at the same time that city council members are elected. It's not as clear with regard to vacancies in LACCD whether they have to be governed by the same principles of the LA City races.
But would they have to, who has the authority then? They have the authority to put something on a ballot for a...
No, they would be able to, we would recommend that they seek a clarification or change in state law. State law governs.
So they'd have to change state law, for instance, to do vote by mail or to...
Well, it would be, I think there's a good argument that we could do theirs with vote by mail or ranked choice voting because of an education code provision that says their elections are to be done like ours. However, I think they'd be on more solid footing if they did seek state law clarification on that issue as well. We can work with...
But what is the process for a community college ballot initiative?
For a ballot initiative, I'm not quite certain, but a ballot initiative for the community college district, I think they would work with the county to put that on if they wanted to do that. I don't think they have the same rights as a charter city or a charter county to have design their own election systems. Yeah, and to put on a ballot measure. They are governed in many ways by the state election code and state education code.
Because when they came, 2 years ago, I don't know if they ever passed something, but they came to us 2 years ago during these deliberations on then IRV, and they said, please do this, or at least individual board members did. But
I do know, I remember that they were supportive of it, individual board members were. Vacancy elections of LACCD also, there's a couple of particularities. One, they don't need to be scheduled within a particular window such that they're almost always consolidated on to a county or city election that's existing, so they don't have a standalone election issue. And second, they're at large. So when an LACCD vacancy occurs, even if it's a single district, the entire jurisdiction votes on that. And that's beyond the capability of the clerk at this point to do any type of citywide or LACCD-wide vote by mail election.
Sure.
So I wanted to bring that to your attention too. And one final point while I have Mike is if you do recommend the ranked choice voting include an option for it to be a citywide ranked choice voting system, not just for special vacancy elections, we would need to know what the election date would be. We have in our current charter a March primary and a May runoff with the idea of a ranked choice voting provision going on the ballot that would perhaps in the future cover all city elections. That needs to be in the charter, what the new election date would be under that system.
in the charter, is it described as primary? It's always been a little bit of a misnomer because it's not a primary in any traditional sense. It's if somebody wins, they win. It's the first election, and then there's a runoff.
That's right. The charter calls it a primary nominating election, and the next election is called a general municipal election. But if someone wins a majority outright at the primary, they clearly win, and there is no general runoff for them.
Okay. David, do you want to add something briefly on that?
Yeah, briefly, I can address those last 2 points. First, we would support having the election date, if it was RCV, be the current general election date, so it's closer to the time that the new terms start. You don't want to have too much time between an election and the turnover of terms. That's why they moved the presidential election date of the United States back from March 4th into January. So we would just say not have an election on the primary day. Now, on the community college district, we realize that there may be a need for state law changes so that community college elections can be on the same date we have ours and the same way we have ours. And I've reached out to a couple of assembly people, one of them in particular who's an educator and a longstanding supporter of ranked choice instant runoff voting, to make sure that they would be willing to carry a follow-on bill if necessary. And of course, if we were implementing RCV citywide in, say, 2017, there'd be plenty of time to have that passed. And this assembly member has expressed a willingness to carry such a bill.
Okay. Thank you. Okay, I think there's a desire to move this forward. I think Ms. Hahn would like to do it with no recommendation per se, but just
move it forward,
put the option. I would like to include the option, though, on school district, so if you can kind of present to the council how that would be part of what we might do for either vote by mail or ranked choice voting. The the lifting of the cap piece, just to be clear, the cost there is because we can't sweep anymore, not because we're already putting that money in, but we sweep out what's left? Is that accurate, maybe Mr. Seeley?
Oh, right, that's accurate.
Okay. All right. I'll state for the record, I'm in favor of these, but in the interest of moving a committee report, we'll move this forward with no recommendation. I'll continue to speak to the desire that I have to lift the cap, to figure out how we can do some sort of ranked choice voting and vote by mail. But I think the cost on the only thing I would amend is the cost on the ranked choice voting might not be accurate to call it 40 million. I think it's the 1 or 2%, which is also somewhat of an estimate. We know that this is going to be a guessing game until we actually have the equipment. But I don't want my colleagues to think, oh, it's zero, but if you do ranked choice voting, it's 40 million. It's going to be, if we buy new equipment, 40 million. So let's make sure the language is clear with that too. Okay?
Okay.
With that, we'll move it forward.
Right.
Okay. Yeah, Mr. But wait a second, Mr. CLA.
Just one clarification relative to lifting the cap. Lifting the cap, what I would recommend is lifting the cap but not requiring that annual appropriation be made.
Okay.
Otherwise, what you're setting up is a charter requirement to appropriate $3 million every year in perpetuity.
Well, part of the idea is to
how
build,
much is sitting there.
There's all sorts of nodding and shaking going on in the audience. Let's get, if we can, the ramifications of that, so we can vote on that instead of having a particular recommendation on doing that or not. I think some of us would like to see that built up, so we might be able to do full public financing one day, and that's a critical piece of it. I also, though, would not want to see us have budgetary implications for the next couple of years, for obvious reasons. We're laying people off, we're doing other things. It would not be the smartest time to be sweeping an additional $3 million away from the general fund. Okay? All right. Thank you all, and thank you for your patience, everybody. This meeting of the Rules and Elections Committee is hereby adjourned. Sunlight will come back tomorrow.